leave my lord, to move this matter my lord, tomorrow. My lord, a demolition order has been passed and my building will be demolished on 21st, my lord, which is on Monday. But the demolition order, my lord, we have received it on 14th. The order was issued. But we have received it yesterday evening, my lord, and an appeal is pending for the building tribunal. But my stay application has also been rejected. My lord. I have challenged that order, my lord, as well as the order.
Yes. Hard copy or the certified copy you have got?
We have copy.
Lord, under extreme compelling circumstances, Lord, I am mentioning this matter. This is item number 567 in your lordship's list. Lord, the next date has been fixed on 23/7/2023. Lord,
Have you mentioned yesterday?
Lord, I could not mention yesterday. Lord, kindly bear with me for a minute, my Lord. My Lord,
Why did not mention yesterday?
7.2 has been rejected despite I have tendered the challan, my Lord. My Lord, the court has not find it in its record, my Lord.
Mention the urgency hand over the
Your Lordship, it's a partnered hearing at your on a visitation. On the visitor, I have not made any matter as part from the previous court had heard it. Here comes
the order that made part. I have not made any matter as part.
No, it is a jurisdiction which has come under you. It was under another.
It is a different thing. So it's not a part. I have not made any.
A lot of problem on the visitation. They are coming with the police and all that, your lordship. And the lower court also is giving another order while this is pending. So kindly one hearing and you will be able to finalize.
And about the slip mentioning the article.
Thank you.
Item number 1123.
What do you want?
There is a
What do you want?
Lordship, there is an interim order which will expire this month.
Sir, what do you want?
Lordship, I want your Lordship leave to dispose of the application for substitution. So your Lordship
Substitution within time.
within time, your Lordship.
Cannot be done here. Register Lajima. Register Lajima. Yes.
May I allow to mention?
Write it down that substitution application filed in time. So it will be appearing under to be mentioned. Please put it in the mention.
Section item number 51, the list of July, my lord. The matter is appearing section 24 application. So
Section 24.
My lord.
Monthly list of
July, my lord.
what is the item number?
My lord, item number 50, my lord. 50, my lord.
50.
50.
50 টা দেখে দিন for want of integration let the matter go out of the list.
Your lordship.
Item number 50 monthly list.
My lord, may I allow to mention CO 2367 of 2025, my lord. My lord, right over the property, my lord, will be gone, my lord. E-auction will be started from the 1st August,
I
my
did
lord.
not mention yesterday. Please come on next Wednesday.
Item number 404 in today's list, restoration appeal. Kindly fix this.
Item number
404.
Yes.
This is a restoration application. Kindly fix this matter at 2 p.m. Lordship.
I will fix the date. Yes.
Lord, 1227, Lord, very short matter, Lord. Only your Lordship had passed this order, Lord.
What do you want?
Lord, kindly,
Upgradation.
Lord, upgradation, Lord, as to be mentioned, your Lordship
Please
would.
mention next Wednesday.
Lord,
Yes.
I also mentioned last Wednesday, that is 9th July. Lordship, item number 92. In connection with the matter, I filed an application for substitution. This is not simple substitution, like petition number 2 and petition number 3 are already in record on the
Lordship,
My lord.
mention matter for release, your Lord.
And over the slip I will come.
Matter for release.
Last Friday. Your Lord, last Friday was not accurate. That is why I mentioned.
My lord. My
Yes.
lord, may I?
Call the list.
Lordship, may I be permitted to mention one matter which is running in the monthly list? Your Lordship, I have applied
What
for
do
the
you want?
certified copy. So kindly direct the to send the file before the department so that I can obtain the certified copy.
Certified copy.
Yes, your Lordship.
Its final order has been passed.
No, your Lordship.
So you can get a further copy.
Your Lordship, certified copy is required for before the learned Barasat court, your Lordship.
Why? Server copy, the learned Parashad court is not acting.
Your
It is
Lordship,
mentioned.
along with this application.
There is a reported judgment on that server copy has to be. Yes, call the list.
My lord, on 9th of my lord, on the 9th, I have mentioned this matter, my lord. Please to release this matter.
Yes. Hand over the slip. Yes.
Item number 96, I am seeking upgradation. But there is extreme urgency.
Please hand over the slip. Mention the urgency. Call the list.
But today it will be taken because there is a third party interest.
Yes. Call the list.
Third party property. But I am handing over the slip.
This matter.
Appearing on behalf of the petitioner, Lordship.
Same order, yes.
Item number 3,
My lord, I am for the petitioner, my lord.
I am for the respondent. On earlier occasion, my lord had heard this matter on 11th.
Yes.
It was kept for CAB.
Yes. Mr. Chatterjee asked the inspector in charge to depute some person to bring the padlock, the keys. Bring the keys. Keys. Ashwin. Yes. Ashwin.
Item number 5 with 6.
May it please, your lordship.
Yes. Yes, Mr. Rai, anything you want to submit?
Only one thing I will draw it to your lordship attention so far the section 32
Section
32
of,
of the new act 1997 act corresponding to section 21 of the old act,
yes,
that the provision for payment of rent and without issuing any rent receipt to that effect. The similar provision is there in section
yes,
30,
yes, that you have to make an application.
not only a stringent condition that shall issue a certificate to the tenant in respect of the rent paid. Previously, my lord, only to the direction of the landlord that he should issue the rent
Now
receipt.
certificate.
Now the certificate issued by the rent controller, it is not. And so far the word rent which has been mentioned, my lord, if your lordship kindly consider.
এই দেখি একটা কথা premises change. অনেক দেখে মনে হচ্ছে তো অনেক পুরনো বই।
Now, my lord, if your lordship kindly consider section, the rent, the word rent is not been defined in the statute itself. Now, last occasion I have handed over to your lordship, my lord, kindly consider 1990 Supreme Court cases, 1990 volume 2 Supreme Court cases, page 651.
volume 2, yes.
My lord will find here, my lord, 32 rupees was fixed on account
Paragraph.
of, it's a small judgment, my lord, paragraph 3, your lordship will find.
Yes. Rent will include other amenities also.
So even if here, my lord, what happened? 32 rupees
So
was
that is not the case here.
No, here is the deposit that precisely where it has held. The initial, it is the range of rupees 32 and 8 rupees per furniture.
Yes.
Paragraph first
paragraph.
First paragraph, because that is why he deposited rupees 32.
Yes. Yes.
Trial court dismissed the suit holding he cannot be termed to a defaulter because the rent which he has paid that has been deposited. Appeal court and high court
says that it's a composite amount.
Consider the entire rent. Therefore, I want to submit rent means it is a contractual amount between the landlord and the tenant. Here is the contractual amount is rupees 1,200. There is no dispute about the same. Now that is the rent. That is a component in its entirety. He cannot segregate according to unilaterally cannot segregate the same. So in view of the same, my lord, subsequent judgments, my lord, are also gone through it, and my lord's judgment is also there.
What?
7-3 to that effect.
No. Mr. Rai, this is CO 2227 is your application.
It's my application, my lord.
Acha, please kindly come to in 2227. Please kindly come to the cross-examination part. You have the cross-examination with you.
Yes.
Yes, please kindly come to cross-examination of 11th of March 2025.
11th of March.
OPW1.
Yes.
Have you got that? So please come to fourth paragraph. Please place fourth paragraph. It is a fact. Have you got that? It's not telling.
It's page 74. It is a fact that I was present. No. It is also a fact that my father demised issued monthly rent receipt of rupees 500 in favor of Tapan Kumar.
It is a fact that my father had issued.
Yes.
Rent receipt of rupees 500 per month.
Yes.
In favor of
Tapal Kumar Pal.
All in respect of the suit property. So this admitted.
Yes.
Next, please kindly come, skip another paragraph, then kindly come to the next paragraph. I do not know.
I do not know whether Tamal Babu spent rupees 2,50,000.
No. Prior to that. Just paragraph before that. I do not know as to why my father issued.
Yes.
So you have also admitted.
Yes, there is an admitted case, 500 rupees rent is issued.
Yes.
But it
So,
could be considered by Kali comes to page 72.
Page
72. Process examination. It is a fact.
Page 72, yes.
1, 2, 3, 4 lines from the. It is a fact that as per tenancy agreement, the rent amount is fixed rupees 1,200.
Mr. Rai, there is no dispute that there is a tenancy agreement. Tenancy agreement rent is 1,200, no dispute. But according to him, he has paid 1,200, but you have issued receipt of 500. Issuance of receipt at the rate of 500, not disputed. He also says that you have received, you have issued rent receipt for 500. It's also your case that yes, you have received rent receipt of 500. Your case is that he has paid 500. I have issued receipt of 500. His case is that he has paid 1,200. You have issued receipt 500. So this.
No, I am not on the receipt. Markali, assume I did not issue any.
Now, according to you, the rate of rent as per the tenancy agreement is 1,200.
His admission 72.
Yes. So it's his admission. He is required to deposit 1,200 along with the application. And for which month you have said that he has not paid? 1 month you have said, 1 month default you are saying that.
Internal page 3 of the order impugned, your lordship, this is a finding.
No, is it a correct finding?
I do
Are
not
you challenging that?
Yes, my lord. This is
You are
not
challenging.
my lord, this is not a correct finding because my lord, the petitioner has already paid from the month of March to from the month of May onwards. My lord, they have deposited the rent.
May, April.
My lord, April, he has already paid the rent amount to the landlord. My lord, it is my specific submission in the written statement. My lord, kindly comes to
Not the written statement. 7-2. 7-2. What have you said? No, all right. I will come. Mr. Rai, please take me to that impugned order once.
That default of in respect of 1 month.
Yes, you have said that there is a default of 1 month, and you wanted to cite some
that your lordship find internal page 3 at the top.
Page 3 at the top, yes.
My lord will find. Since it is admitted fact, second line from the top, my lord got it.
Yes, since it is an admitted fact that the defendant petitioner has deposited rent of 500 per month at the rent controller and civil court on and from March 2016, excepting the month of April.
So this is the finding is recorded.
So according to you, court arrived at a finding that April he has not paid. He has also not deposited along with that application. So 1 month default, whatever may be the rate of rent, he is not entitled to have its application adjudicated.
To be
adjudicated. So anything more, Mr. Rai?
And 7-2, my lord, once 7-2 that admitted rate. Paragraph 6. Page 45.
Page 45. Yes, rate of rent is 1,200 as per the.
So therefore, my lord, irrespective of fact, what is the today, my lord, if your lordship I did not issue any rent receipt. I did not issue any rent receipt. 75 rupees, 525, that is immaterial. I did not issue any receipt. Records are there. That is why in Royal page 30, section 32, coupled with section 7. And the judgment, and my lord Kali, my lord is looking at the form 2 rules. Where is that application? I could not understand.
Yes.
So, in view of this admission, my lord, what is the rate of rent? Nothing. So, admitted rent, irrespective of fact, what you have deposited to the rent controller, the rest amount required to be deposited. Along with that application under section 7.2. Because it does not say the rent deposited, rent, last rent paid. The rent paid includes, my lord, the tender to the landlord.
Yes, anything more?
That is
Yes, show me that, April 2016, what is your statement with regard to?
May I just take a lordship to page, internal page 2 of the order impugned, my lord.
Internal page 2, yes.
My lord, after the citation of judgment Remington brand, my lord kindly comes to second paragraph, last 3 lines. In his written statement.
Oh, please give me a minute. Difficulty is that you are annexing the evidence certified copy also.
My lord.
I'm searching for the impugned order there. Impugned order, page 2, yes.
In the page 2, my lord, in the middle,
Yes,
after Remington brand citation, my lord, in the
Yes.
last line, second paragraph,
yes.
in his written statement, he has admitted that when the plaintiff number 1 stopped receiving the rent
No, no,
since
no,
March
no, no.
2016,
Please wait. In the Remington rent, such and such, in the instant suit, it is
in the
admitted.
statute, in the last 3 line, my lord, in
Last,
that particular paragraph,
in his written
the
statement.
statement, he has admitted that the plaintiff number 1 stopped receiving the rent since March 2016. The defendant started paying rent to the rent control at the rate of 500 per month, except the month of April.
Yes, so except the month of
My
April
lord, this is not
2016.
my admission in written statement. This is my respectful submission.
All right, show me your section 7 to what have you stated
My lord, in section.
with regard to April 26.
My lord, if you lordship can take section 7(1) once. Miss page 35. 7 on application.
7(1),
7
page
35 of the application.
yes.
My lord, second paragraph. Second paragraph is the next
Tendered rent by hand up to April 2016.
up to April 2016.
Oh. Any objection, Mr. Rai, to this statement?
Yes.
My lord,
You have filed a written objection.
Yes, your lordship can.
My lord,
May I-
All right. Yes, sir.
my lord, therefore, my lord, if your lordship kindly takes page 68, my lord. Of the my lord, cross examination, of the examination evidence, my lord. Page 68.
Yes.
My lord, in the middle, it is a my lord exhibited document. Exhibit number 5. My lord,
I have filed 23 photocopies of rent control from March 2016 to December 2018.
collectively.
My lord, how could you be, if your lordship can consider, it, if the landlord take rent up to from the till month 2016.
My
It's
lord,
their
may I just take
application.
your lordship to my lord one more application of the petitioner, my lord, the plaint itself.
Yes.
My lord, page 63, which is the evidence of my lord, evidence in chief of the petitioner, my plaintiff, my lord, tenant.
Page
63, my lord.
yes.
My lord, paragraph number 10.
Yes.
The defendant is a defaulter in payment of rent since February 2016. Right?
Yes.
But in the my lord can takes the plaint itself once, my lord, which is in page 20, my lord.
Yes.
My lord, there in paragraph number 7, he has stated, my lord, the defendant had paid partial rent up to February 2000 since December 2020. My lord, now, my lord,
Up to February 2016. So March, you are a defaulter
my
according.
lord, my specific submission, my lord,
Oh, since.
since
All right, that is his statement.
statement.
So your statement, show me your 7(2).
My lord,
He
7,
may have said something that will be adjudicated.
my lord,
What is your admission? What is your case made out in 7(2)?
my lord,
Because you are disputing, you are entitled to dispute everything.
my lord.
So show me what is the dispute which you have raised.
My lord, page my application number 7(2).
Yes.
My lord, the last the paragraph number 3 itself.
Paragraph number 3, do you have a better copy?
My lord,
Till now, not a better copy.
But last line, if you consider, my lord, in page 40, first line, receipt of rupees 500 per month to the defendant, month on and from September 1999.
Have you stated anything with regard to April?
My April I have stated in my written statement, but my lord,
Show me your written statement.
My
What have
lord.
you stated?
my lord, may I take your lordship to page 28?
Yes, 28.
My lord, second paragraph, third paragraph probably, my lord.
What is this? Page 28 is there?
My lord, the written statement of
Or is
the
the written statement?
my lord, defendant used to pay monthly rent of 500 per month to the
Tendered rent by hand up to April 26 against the issuance of rent.
rent receipt. my lord. The plaintiff and his basically issued rent receipt time to time. Thereafter, on and from May 2016, the defendant started depositing the rent before the learned rent controller, Kolkata. My lord, may I just take your lordship to evidence of my lord cross examination of petition plaintiff, my lord, landlord, which is at page 75 once.
75. Yes.
My lord, 7 paragraph. I found the photocopy of said tenancy agreement in the year 2015 after demise of my father.
Yes.
I also found the original copy of the said tenancy agreement in the year 2015, later after demise of my father, my lord. My lord, this dispute arose after my lord he received found out the tenancy agreement. But prior to that, from 1999 to 2000 onward, my lord, he was receiving rent to the tune of rupees 500, and he was issuing rent receipt, my lord.
But you have also said that you paid
My lord,
1200.
fact, my lord, it is a factual defect. My lord, it is a factual defect because it is their case.
Not a
They have
factual
claimed,
defect.
my lord.
You admitted that.
My lord, my admission, my lord, what is there, my lord, I cannot change. But what happened, my lord, the point is, my lord, this petitioner, my lord, raised the dispute in this plaint that after I found this copy, I have realized that it is 1200 per month. Prior to that, I was not in aware, my lord. But he was not eagerly, my lord, issuing rent receipt after 500. After the file this receipt, my lord, my lord, tenancy agreement, thereafter, my lord, our condition was that yes, no, I have given 500 rupees. I have given 1200 receipt. You have issued me a receipt of 500. But the factual aspect is, my lord, he have paid 500 rupees as a last paid rent. He has paid 500 rupees to petitioner. Plenty. Yes. My lord, may I just take your lordship to my lord, the impugned order, the findings, my lord, on the basis of my lord, the written statement made in the written statement. This land court below came to a finding that he have deposited rent except month of April, but it was not correct, my lord, because the exhibited document is there, my lord. Because I have issued, my lord, I have exhibited each and every statement from from March 2016 onwards till March 2018.
And please kindly come to 7.2 application 1.
Right.
Paragraph 6.
My lord.
Did you adduce any evidence with regard to paragraph 6?
My lord, this paragraph number 6, my lord, in presence, the evidence, my lord, the witnesses, witnesses of the tenancy agreement.
Page 40, paragraph 6.
I have gone through, my lord, the plaintiff renovated the suit premises at his own cost, due to the fact that at the time of induction of tenancy, the suit premises were on dilapidated condition.
Have you adduced any evidence with regard to paragraph 6?
There is no documentary evidence, but my lord, the
documentary oral
evidence. My lord.
Please show me.
My lord, may I take your lordship to page 70, 71, which is evidence of my lord Shamul Chakraborty, my lord.
Shamul Chakraborty
is the witness of the tenancy agreement.
Yes.
Where my lord, this plaintiff also itself is a witness to that agreement.
Yes.
My lord, may I take your lordship to page 71? My lord, last para. My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. My lord, 9 para from top, my lord. 8 para. Not a fact that I have stated falsely as per the instruction of Tapan Pal that he has spent 2,50,000 for repairing of the suit property. But it's a suggestion has been given. But in my affidavit in chief, which has adduced as evidence of Shamul Chakraborty, he has stated that it was given, my lord. in every chip of
Show me that,
my lord.
chief.
My lord, page 58. Page 58, my lord.
Yes,
Or may please, my lord.
yes, anything more?
Page 59, para 7, my lord, of the evidence.
Yes, I've seen that.
My lord. My lord, one thing, my lord, the application, my lord, may I just take your lordship to the operative portion of the order, my lord, order impugned, for which I have preferred this revisional application. My lord, this is the miscalculation which has been made by the land court below. And below the April rent of April, which was stated for of the findings, my lord, it was not been paid. My lord, last para, my lord. My lord, rent was fixed at 1716 as enhanced rate, my lord. And as he was depositing, my lord, 500 rupees, my lord, the calculation itself was miscalculated, my lord.
No. The rent is, the rate of area rent for the month of April will be 1560. Rate of enhanced rent.
My lord, this is a provision. There was a provision in the tenancy agreement. But that after a lapse of every 5 years, the rate would be enhanced to 10% of the actual rent. My lord, after enhancing, my lord, this amount came to, my lord, 1560 from 2016 to 2020. Which has been calculated correctly in the above portion, my lord. My lord, in the later portion, my lord, you can see that the enhanced rate of, my lord, third last paragraph. 1/12/22 to 53 months have already deposited at a rate of 500 and challan have issued. Rest amount to be payable after 10% enhanced rate of rate would be 1560 into 10%, 156 rupees. Thus, enhanced rate of rent would be rupees 1716 per month. My lord, now this calculation, my lord, without, my lord, deducting the rupees 500 which he has deposited before the rent control challan, my lord, he have totaling, my lord,
So rent control challans,
and my rent control along with, my lord, the civil judge challans, my lord.
yes, that was not considered.
That was not, that 500 rupees was not deducted. My lord, can I see the multiplication?
Anything more?
My lord, that I respectful submission.
Yes, Mr. Rai.
It on page 36.
Page 36.
It is the case made out at the top up to April 2016 against the issuance of rent receipt.
Yes.
Now kindly turn
So
to
according in 7.2, his 7.1 his case
56.
is that up to April 2016 he has stayed there.
page 56.
56.
17B.
17B.
I said that I am filing the following documents. Malan got it?
17B.
Yes.
Page 56.
Yes, 56.
Oh, 17 paragraph. Yes.
I am filing the last original rent receipt for the month of February 2016.
Yes.
So this is the last rent receipt.
Yes,
And he tendered rent upon rent receipt was issued in April 2016. It is a statement made.
yes. Yes,
Now, Mal, can you turn to the application? Paragraph 3. On refusal of the plaintiff number 1 to accept the rent for of May,
page.
page 36, 7-1,
Yes,
May 2016. So it is admitted, according to him, that April 2016 rent receipt was issued for the purpose of making such payment. Our case is that up to February 2016, the payment was made. He produced the last rent receipt. Mal, can you record that? It is his specific case that
February 2016.
16. So March, April, there is no rent receipt on, but he said it was tendered and last rent receipt was issued to that effect. That on refusal of the plaintiff number 1 to accept rent for the month of May 2016, the defendant tendered rent by money order on and from May 2016, and this defendant started depositing the rent controller at Calcutta from May 2016 to March 2018. Pause there for a moment and can you turn to page 56. C. 17C.
Yes,
This is 20 number of original rent challenge showing deposit of month of March 2016 to May 2018.
yes, yes,
Next year, Lordship will find, I am filing the original deposit challenge month
so
of,
from March 2016 to May 2018, he has filed 27 challans.
it is his case, the last rent received by the plaintiff is up to April 2016. And he is willing to pay on the month of April 2018.
Yes,
It is his case. I'm reading, placing the affidavit chief, what he has said, not on consideration. And now I can consider whether even if pilot have paid accepted the amount, what is the recourse? Whether it is be adjusted with the rent. Why is the provision?
what?
The excess amount, according to him, that the excess amount has been paid.
From 1200 he has paid. 700 extra.
That 4,50,000, 2,50,000, which he have said.
Yes,
The 1956 Act, there is provision. Set off and other things. But the 97 Act includes those.
97 Act.
Whether there is any provision for set up or adjustment of the rent. I put this question to myself.
Section 17, there was a provision.
56, there are some judge. 56,
Community provision in section 17.
because it is his case which
Mr. Rai, the landlord cannot take anything more than the contractual rent.
yes, there are the consequences.
So, if
Consequences. My lord, that I beg to. My lord, can you consider the consequences for taking excess rent?
yes,
Any tenant or landlord or person who contribution receive any sum, pay section 30.
yes. No, that is fair rent.
No,
13 is fair
any
rent.
landlord or any person who in contravention of the provision section 14. Section 14 is the fixation of fair rent.
Section 13 is rent in excess of fair rent not chargeable. That is
Yes.
rent in excess of fair rent.
And section 14, my lord, can you consider?
Yes, yes.
No person shall in contravention grant, renew or continuance of tenancy of any premises, claim, demand or receive any sum, premium or claim, demand, receive any compensation in cash or kind in additional rent, except with the previous.
So according to you, he could not have paid.
He could not have paid. It is him, and it shall not.
Have you considered my judgment? I have delivered a judgment on this section.
That adjustment is permissible. That if that is so, my lord, if it's unlawful to tenant to any other person acting on behalf of the tenant to claim.
I've distinguished, I've said when section 14 shall be, in what case it shall be operative. Restrictions shall apply when.
These restrictions are applied for the purpose of set off the claim of the area rent.
That is, I have discussed, relying on a earlier division bench judgment of our court. And I have distinguished another coordinate bench judgment on this.
That another.
So this is section 14 is a different thing altogether.
So today,
I've held that when this restriction shall apply.
today the seller.
It is a different thing altogether. So
So
now
what will be the salary? The what salary? It is a security deposit.
have you seen that decision? You have,
I do not get. It is
I
not been
think
default
if
subject.
I remember it correctly, Mr. Taraknath Haldar appeared in this matter, in that matter.
I have to. So as of this day, Mylar has to consider whether the last paid rent has been deposited or not. And what is the last paid rent? Whether it is the amount which is deposited to the rent controller or tendered to the landlord.
Always. Anything more?
And so for the admission on that part, today.
Gratefulness.
415. Yes.
Gratefulness.
Item number 7. Yes.
I appear on behalf of the opposite party.
Yes, Mr. Bhattacharya, what is the challenge?
Supplement affidavit only for after degree was passed. There's a subsequent event. They put the degree into education. They filed an application.
What is the order you are challenging?
Order occupation charges. I prefer an appeal.
Oh, this is
The
that
applicant
matter.
assess- Yes. Assess the occupation charges without any minor. Is there any with any assessment? What is the assessment? My lord knows the Aftaram case, my lord. There must be, my lord, it's a fanciful. Only can you see, my lord? Advantage of yes. After going through the case record as well as the state petition and after hearing the learned advocate for both sides, this court is inclined to allow the state petition till the next occupation at 10,000. Without any determination of prevalent market rate and with reference to stamp decoration, nothing. You pay occupation just 10,000. Now at present I am paying 1,600 till January 2025 I paid. And the schedule.
No, one thing, Mr. Bhattacharya, it is, please kindly come to the order dated 12th of February 2025.
Yes.
So this was, written objection was filed to the stay application.
Yes.
And then after going through the case record, please kindly.
Yes, after going the
as well as the stay petition and after hearing the learned advocates for both sides,
yes.
this court is inclined to allow the stay petition till the next date, subject to, till the next date. So the learned judge was of the view that quantum will be decided.
What will be decided?
That submission could not have disposed of the stay application. So I'm directing, tentatively you pay this, I'm directing the stay application to be heard. Yes, madam.
My lord, that is my contention. If they were preferring a civil revision, they could have sold the bona fide and they could have made the payment of particular amount. The 10,000 is not a very big amount. They are occupying a premises which is.
I know. That is what I
Yes, when the decree was
My
passed,
lord.
Mr. Bhattacharya,
Yes.
when the decree was passed,
By
lord, it was
22nd December 2023.
22nd of December 2023.
Yes. And
So,
till January I paid
19 months.
9.
You have not paid anything?
Yes, 1,600 till January.
1,600.
Till January.
All right. So,
Till January.
and what according to you is the market rate of
3,000. According
3,000?
to 3,000.
All right. So, for 19 months,
Yes.
3,000 rupees, how much it comes?
60,000. That is 57,000.
57,000.
57,000.
So, you deposit 50,000. I will be directing the 50,000 within 2 weeks. I will be directing the.
But
So, I'm accepting your rate.
yes.
Yes.
But that is spelled out in the earlier order here also. But 1,600 I have paid only till January.
Bhattacharya, this will be adjusted.
Yes, yes.
So everything,
Yes.
so for the present, I'm also not said 57,000. Deposit 50,000 within 2 weeks. I will direct the stay application to be decided. I will give them liberty to
Yes.
file an application and documents in support of their market rate.
Yes.
You will also, and that will
Yes.
be,
Then-
and this amount will be adjusted
Then
with the amount.
I accept it. But what I am submitting, the 3,000, but then according to me, my 1,600 I have paid, madam.
1600, Mr. Bhattacharya, 1600 will be decided thereafter. Everything will be adjusted.
At the time of the hearing of the same.
Now, consolidated amount, I have not said 57,000, 60,000. So I have accepted your rate. I have not done anything more. According to the code, 10,000. So even if you add 1,600, it will be less than half of the amount. So I have not said that. 3,000 at your rate, not even 57,000, but deposit 50,000 within 2 weeks.
50,000.
Yes. Otherwise, this order will stand recalled. That order will stand revived.
That will be
My lord, I just want
readjusted. But what I am submitting, but what is the reassessment, my lord? The learned trial judge, my lord, learned appeal court will reassess the occupation charges.
Everything.
And thereafter he will kindly.
But provided within 2 weeks you deposit 50,000.
Yes. But kindly record him, my lord. That will be subject. That will be decided. That will be adjusted by the lord.
Yes, everything will be adjusted.
Tentative. Yes.
Within 2 weeks?
Within 2 weeks.
Yes. Within 2 weeks. That has to be done.
But just a minute.
Your rate I have accepted,
Yes,
Mr.
yes.
Bhattacharya. And till date you have to pay.
Yes.
You are ready. Yes.
My lord, my
May
instruction.
I submit it by 7 days? But I am not bargaining, my lord, only 3 weeks. In place of
2 weeks. 2 weeks.
2 weeks.
Yes.
My lord, I'm
Pay to the landlord 50,000 within 2 weeks.
Yes.
If that is done, then I will direct you file your
We shall do that. My lord, I just wanted to add that my learned senior friend has submitted that they have been continuously paying 1,600 rupees. My lord, my instruction are that they have not paid a single penny to my client.
I haven't taken into consideration 1,600. So I have accepted at the timing their rate.
Yes.
Ashwin. This application under Article 227 of the Constitution. আচ্ছা ওই order-
আপনার ডিপোজিট সাপ্লিমেন্টে
yes,
The last occasion, my lordship, please to direct my learned friend
To take instruction, lordship, lordship.
get the instruction.
Lordship, instruction, that means I have.
No
filed an
order was
application.
recorded.
No, lordship. Lordship, I filed.
what instruction?
The instruction lordship is total, lordship, kindly see page 12, the shoot value, at first is shoot valuation. Shoot value is more than 2 lakhs, lordship, but the,
আগে আসল জিনিসটা বলো, এবার দিন।
What was the instruction that?
I withdraw the suit, lordship, and file a fresh same cause of action. Lordship, due to lordship, the suit filed before the learned civil junior division, but see, valuation of the suit valuation, 2,200.
Show me the plaint, what is the suit valuation?
Lordship,
My lord,
kindly.
initially, the prayer was for my lord, withdrawal of the plaint. That has been rejected, against which he has come up.
Lordship, page 12, lordship, সত্য ঘোষণা ও স্থায়ী ইনজাংশন প্রার্থনার জন্য মূল্য 200
Yes, 200,
and next খাস দখল পুনরুদ্ধারের জন্য
yes,
That's it.
200.
200 but the recovery of addition should value more than 2 lakh.
At least you have valued your suit. That cannot be accounted for.
That's matter not a jurisdiction of the than a civil junior division. That is as per suit. That's my suit valuation.
Pray for return. Pray for return.
That's I am withdraw this suit for 3 counts. File
No liberty. Liberty will not be.
without liberty you cannot be on interfere. Let's see liberty to file a fresh before the appropriate court. Lordship. Otherwise,
Not on the same cause of action.
let's see cause of action. Lordship. My case is suit for recovery of cash position, lordship. But my position, lordship, I mentioned this, lordship, page 16, para 5A, 5 ক, lordship. বিগত ইংরেজি 23/6/2016 তারিখে বিবাদীগণ তাহাদের হস্তগত লোকজন লইয়া মারাত্মক শস্ত্র সজ্জিত হইয়া
Yes, what is according to you the valuation of the suit?
that my DD says that the suit valuation is more than 2 lakhs, lordship.
More than 2 lakhs. All right, I will record that.
Lordship. In this and lordship,
So I'm directing them, recording is sufficient that the suit value is more than 2 lakhs, for which he wants to withdraw that and file before the appropriate forum.
lordship.
Lord, Lord, in the application,
I'm recording is sufficient.
Lordship, record is
no reason was assigned.
can record it. But see, learned tal, learned
Yes, I will record your submission, Ashok. The Yes, call the next matter.
Item number 9.
Coming after 5 minutes.
After cross-examination, examination of plaintiff and defendant number 2 were closed. Defendant.
Extension of interim order.
My lord.
Defendant
Yes.
number 2, madam.
Yes.
Well, the interim order has
Interim order
left in
expired in
the
April.
April 30th, April
Yes.
2025, madam. And no, if any application has been filed, madam, we have not served with any application, madam.
Serve him a copy. I'm extending this. This is an application for extension of interim order.
But I have added by way of amendment, one one property of the petitioner was added. Well, I sought for commission of that property, my lord.
Till when it was, the interim order was
Interim
there?
order is till the month of June, end of
Yes.
June.
Why did not mention it earlier?
Well, I mentioned it. Thrice, I have to file an application within time. Well, I mentioned thrice, my lord.
When did you mention?
Well, I mentioned in the month of July as well as in the month of June, my lord.
June, when did you mention?
My lord, I don't remember the date, my lord, as such. But I have mentioned in the month of June, my lord.
Please supply me the date because I have to check. Because all matters for extensions which were mentioned in the month of June, all were data. Please supply me the date when you mentioned.
Let's check with the June.
I will also have to check my records because something is
But
going wrong or not.
matter, my lord, I must indicate, my lord, this matter was mentioned twice. At least I have come and mentioned twice in the month of July, my lord. So
July, I am not
July,
saying prior to expiry.
Well, prior
You
to
have said
expiry,
June also. That is
June
why
as
I
well.
want to
June
know,
as well. Yes,
because I have also to verify my records. This
I will have given notice to my other side as well.
this application.
Oh, Chilo.
Have you solved this application?
Yes, my lord, sir.
Yes, next.
Much obliged.
Item number 12. Yes.
But in a suit for declaration and injunction, but boundary dispute, but I filed an application for local inspection. Now, but the Learned Advocate Commissioner submitted. Don't go by the prayer of the which has been turned down. That prayer can't be allowed, Marat. But kindly see the commissioner's report, Marat. Commissioner himself admitted. Kindly see page 10. Kindly see page 10. It should be before the appeal court, Marat, a further inspection. Not on the ground of remand, Marat. But that is wrong. Kindly see page 10.
I could not follow you.
I'm telling you. My client as a plaintiff filed a suit for declaration injunction, dispute regarding the boundary wall and there's a passage. And according to us, there was a previously latrine, now that is removed. Number in that score, I filed an application for local inspection before the trial court. Kindly turn to page 10, the commissioner's report. The Learned Advocate Commissioner stated before in the report that after receiving the writ, I have sent a requisition to the district magistrate Nadia for obtaining RS and LR Mauja map, but it is not produced yet and said authority. Number the local inspection petition was directed to consider with the Mauja map and the RS LR record, but without considering, he admitted he filed the report. Now, ultimately, as we could not prove on the basis of the commissioner suit dismissed, we filed an appeal. In the appeal court, we filed an application for local inspection.
Why?
Because in order to show, because
There's a commissioner's report. What is the necessity of?
Why I'm telling you, kindly see the.
Where is the plane? Show me the plane. What is the suit for? What is the suit for?
A suit for declaration injunction. I have to bring the copy of the plaint for it.
Yes, yes. What is the suit for?
Declaration injunction.
Yes. Declaration injunction. Why local investigation?
But there is a dispute regarding boundary wall, my lord. Now,
commissioner's report is there.
Commissioner report, kindly see once, my lord, page 10. Kindly see once, page 10.
Yes.
And the commissioner himself stated, my lord, he could not, my lord, complete the commission work. Kindly see page 10 once.
But he did not take steps thereafter.
We filed objection. We filed objection that is one of the ground, your lordship knows, my lord. If that has not been considered in the appeal, we can take that plea. Now, if I bring the plaint, my lord, kindly give me a 1 day, my lord. I will bring the plaint, my lord, to your lordship.
Once not bring the plaint, your submission has been recorded of the advocate.
My advocate submission, man, don't go by that, my lord.
Yes, yes.
I
Are you disputing this?
No,
then go there. If you are saying that the advocate did not say that, withdraw this, file a review application there.
In the court below. But kindly give me 1 second. But kindly give me liberty, I will withdraw this.
No.
Yes, I have taken the instruction.
Maybe.
But I'm not pressing this, man. I will file application.
You're not pressing. I will dismiss it as not pressed.
This will not prevent me to file application.
No. Yes, you can withdraw, but not leave. That's not a matter of right.
No, I am praying.
So,
I can't matter.
Yes, so there are 2 courses. So it cannot be segregated.
No,
if
both
not
conjointly.
Yes.
Conjointly.
Conjointly, if it is rejected, then you have to either press or it is to be dismissed as not pressed. That's the law.
That is the law. We are learning. If you lordship kindly give me some time, I will. It is my suit and my appeal.
Maybe.
But kindly visualize.
Maybe. Only because it is your suit, you cannot prolong that.
I am not on that. But the question is that, if I ultimately could not prove that, everything will go. What will remain in the appeal if I put this question to myself? Nothing remain will in the appeal. But kindly visualize that portion, but kindly see once, may I, it is can I bring a type copy? It is in Bengali.
I can read Bengali. May not be as fast as you can, but I can.
There's some. Kindly see the paragraph 4. There is a अरे बोल তুই আবার কি খুলছিস প্রিন্টের কপি ওখানে নেই কি বল আরে if the advocate commissioner states himself that I could not LR Mauja map and RS Mauja map I could not bring or the district magistrate has not supplied. I don't know why he wrote to the district magistrate. Kindly visualize my entire suit will go.
Yes, paragraph 4. What do you want to say?
No, I want to say, my lord, so to your lordship, my lord, that there is a dispute regarding passage and the latrine, my lord, which they have removed. Now, my lord, in order to show whether
Where is the dispute? No dispute is there.
I kindly see conjointly the written statement along with the plaint.
Yes. Give me the written statement.
তুই দাঁড়িয়ে বলছিস কেন তুই? May I file a supplementary affidavit, my lord?
Not necessary. Written statement, I think, is a part of the record trial. Yes, where it has been disputed.
But kindly see, my lord, the plaint. But kindly see paragraph 7 denial. They have denied everything.
Yes.
In the written statement, my lord, what I have stated, they have denied. According to them, there is no existence of the latrine and there is no existence of the passage. And the boundary wall, which I am telling that they have forcibly made a construction of the boundary wall, they also denied the same. For that reason, my kind.
This application under Article 227
ফেরত দাও।
কোনটা প্লিটিংস গুলো থাক।
আগের নামটা চেঞ্জ হবে, ওই নামগুলো থাকবে।
Yes.
I appear for the petitioner, my lord. The petitioner is the plaintiff in the court below and suit for eviction, my lord.
Yes.
Eviction under section 6, my lord. The defendant, tenant, initially filed 7172, thereafter not pressed. Now, thereafter, my lord, he filed an application under order 39, rule 7. So kindly comes to page 39, my lord.
Yes.
These applications so filed without any application for paying for repair. And kindly comes to page 40, paragraph 11, my lord. Paragraph 10. If my defendant also submitted once advocate past commissioner files a report, your petitioner shall make an application for repair and shall effectuate repairing work under the supervision. These applications all came out, my lord, without any application for paying for repairing. Wherein he has approached the court for appointment for advocate commissioner, and if the advocate commissioner files a report, then he will file a repairing, and this application was allowed.
An order of injunction, my lord. Well, I obtain an order of ad interim injunction, my lord.
For the opposite party.
Yes. Well, this is the case in respect to Salt Lake property, my lord, where a decree of eviction has been passed. In the span of 3 months, I was not given any notice, summons not received. My lord, a miscase has been filed, my lord, in respect to the execution case, wherein a dead person has received the summons. Well, all these things are there.
When the suit was decreed ex parte.
Yes, suit filed on 30th August 2018. Suit was had ex parte, decreed ex parte on 20th March 2019.
20th of
March 2019. 30th March 2019. Yes,
30th March 2019.
Yes,
decreed.
Yes, within 6 months, 5 to 6 months. Now, my lord, most interesting thing is that, my lord, when they have.
Yes. Now what?
Yes.
The order 9 rule 13 you have filed.
Order 9 rule 13 is pending. Now, my lord, I have filed a.
When have you filed the order 9 rule 13?
Immediately after there, my lord. Now, my lord, I am on a different suit, my lord. I have.
No. Please give me the dates.
My lord,
You may be on a different.
Yes. My lord, within.
Sir, allow him to. He is the petitioner. Please allow him to make a.
Well, if your lordship takes my plaint, my lord.
When order 9 rule 13 has been filed.
Yes. Well, after getting the execution order, my lord, I immediately checked it, my lord, that I have stated in the paragraph, my lord. Lordship will.
Give me the dates. Give me the dates.
Yes.
Those are all stories.
Yes. Not
Please
stories,
give
my
me
lord.
the
Dates
date.
are there, my lord. I'll give you 1 minute.
Yes. Next, what happened?
Well, I'm
Yes,
just
you
on
find
I'm
that-
on a different. I'm on a different one.
Yes.
I have filed a suit, my lord, that decree obtained by fraud is not active. It cannot be, my lord, valid.
Which one is earlier? Order 9 rule 13 is earlier or the suit is earlier?
No, order 9 rule 13 and this after this I have filed a suit. Now, what is the urgency is that, my lord, that portion has been demolished. Now, my lord, there are other tenants, my lord, they have also obtained an order of injunction and ultimately that they have also, my lord, the appeal has been allowed in their favor. Now, I have also obtained an order of injunction, my lord. The appeal court, my lord, only said I am not in possession, so the injunction cannot be carried. Well, I am only in respect to a very particular order, not to take any third party, not to create any third party interest in the meantime, my lord.
Where is your application?
Yes, ma'am. Roshi will kindly takes, my lord, my plaint at page 20 and my injunction application starts at page 33. And the
Page 33.
Yes, ma'am.
So why have you not paid this in order 9 rule 13?
Right. So the practical problem is that, there is no court, the court is lying vacant. Well, it's pending since long, my lord.
Have you filed an application?
Yes.
Injunction.
Everything is there. Well, everything is there.
Yes.
Well, I have on record if your lordship wants, my lord. But today, my lordship will kindly see the order, my lord, at page. Lordship will kindly takes, my lord, page 49.
Sir, you have filed this appeal in 2024.
Yes. Suit. Well, page 49, I have obtained an order of my ad interim injunction was passed.
And when you are dispossessed,
Yes, Mala, I was dispossessed on, Mala, that has been stated in my plaint, Mala. There is a specific case I have made out. Yes. Yes. The plaintiff stated that on February 24, 23, the plaintiff on the very first time came to know about the plaintiff would be evicted from the suit premises on 27 February 2023.
yes,
Now, my lord, after that, Mala, I have taken.
7th of February 2023.
Yes. Well, after that, I have immediately taken all steps, Mala, under the law which are required, Mala. Now, Mala, today,
After
Mala,
1 year.
Mala,
After 1 year.
no. Yeah, I have filed.
2024, the suit was filed.
Suit was filed. After that, by why more? Lordship kindly, Mala. Order 9 Rule 13 filed.
When?
Mala,
That date you could
yes.
not
Mala, yes.
give now.
Page 22, paragraph 9. Page 22, paragraph 9. Lordship will kindly text.
Yes, page 22, paragraph 9.
Yes. Mala, paragraph 7, 8, 9 is very important, Mala. Mala, may I read for your Lordship if your Lordship allows me, Mala? The plaintiff
Give me the date.
Yes, Mala.
The entirety.
Yes, Mala. Upon getting the certified copies, paragraph 9, the plaintiff was surprised to see that absolutely false statements and oath has been averred before the learned.
Those are stories. Give me the date.
Mala,
You have stated everything except the
yes.
date.
Mala, this case was registered as 30 of 2023 at page 23, second line. First March 2023.
1st of March 2023.
Yes.
So 1st of March 2023.
Yes. And Mala, I have pleaded in that February.
When have you been dispossessed?
27th February 2023.
27th of February
2023. So within 3 days I have filed. 3 to 4 days I have filed.
Yes. Yes. Where is the order of the trial court?
Yes, my lord. Lordship will kindly takes at page 49, my lord. That is the ad interim order, my lord, was passed in my favor.
Where is your application?
Yes, my lord, application at page 33, my lord.
Yes.
This is my case, my lord. And Lordship will kindly takes the impugned page, my lord. Page 11, internal page 11, the appeal court's judgment, my lord. Well, he has specifically came to the conclusion that admitted that I was a shop owner, everything is there. And most interesting thing that, my lord, it was a registered lease. Lease expired in, my lord, till the when this suit was filed, my lord, the lease was in existence.
I was shown as a licensee.
And I was shown as a licensee, and this decree was passed.
Similar things happen in our
Yes. Yeah. And Mala, I am carrying all the orders. With other tenants have obtained from different courts, Mala, and even the High Court has also, Mala, come to the conclusion.
same building.
Yes, on in respect to the same building. বের করবো দাঁড়া দুটো কথা হচ্ছিস একটাই খুব খারাপ
What is your name?
my lord Homir Kumar De and my lord, this suit was filed by power of attorney holder Bijon Haldar. I mean, he adduced evidence. He's a developer over there, man.
Yes, this is the ad interim injunction. What is the stage of the temporary injunction application?
My lord, pending, my lord, pending. There's pending. Lordship will kindly seize, my lord. They have
Written
the
objection has been filed.
no.
Written objection has been filed. What is the next date?
That's I don't know, Lordship.
Yes.
Instruction, Lordship. The thing is that, Lordship, if you come to the page number 42, page number
42, yes.
schedule. So, sorry, Lordship, 43, the schedule.
Yes.
The one shop room is going, numbering shop room number 1. That shop room has been demolished, Lordship.
Yes, yes.
So demolished and
All right. So you have demolished that, no difficulty. So, but don't construct there.
Yes.
Lordship, they
Don't construct there.
we are not constructing, Lordship.
You are not constructing. So I'm directing the temporary injunction to be disposed of. I'm recording your undertaking that you are not
Not to
constructing.
construct and not to create any third party interest.
Take my submission as they served me on day before yesterday, Lordship, and I am not communicating with the client till now. As due to network issue or due to
You
another.
have lost the caveat.
Yes, he has lost the
So when you have
caveat.
lost the caveat, you must be having all instructions, sir.
For the instruction of the conducting advocate in the lower court below, Lordship.
Sir, when you have lodged the caveat, you ought to have taken in all instructions then. That's not a ground. I'm directing the temporary injunction to be heard out. Ashok.
Lordship, it has been already been directed by the session code, Lordship.
Yes, yes. So that will be done, but in the meantime, don't do it. This application under Article 227 of the Constitution of India is at the instance
59 for the petitioner, my lord. By this impugned order, the learned court was accepted the written statement after, my lord, almost 3 years. What has happened, my lord? Suit for partition filed on 2021. Now, my lord, the defendants number 1 to 4 appeared August 2022. Ex parte was fixed on August 2023. They have filed, my lord, the 2 petitions for acceptance of written statement and, my lord, vacating of, my lord, ex parte on, my lord, April 2025 without showing, my lord, any clarification, proper clarification.
Where is the application?
Kindly come at page 23. They have stated that due to unavoidable circumstances, the defendant was not possible to take steps properly. Only, my lord, unavoidable circumstances they have written.
The learned advocate appearing for the petitioner may be justified. Yes.
Yes. My lord, the petitioner is my lord, defendant number 1. Plaintiff file a local investigation under section 26 as rule 9 of the CPC, my lord. The report has been filed, my lord, and the by the commissioner has been appointed. Report has been filed, my lord, and accepted by the court.
That's the law.
My lord, we file, my lord.
The law. Have you
It is, my lord.
cross-examined the
But-
commissioner?
No, no, my lord.
You have not cross-examined?
No,
Why?
no giving scope, my lord.
Where is that?
My lord, I have filed my routine objection. Your lordship, page 88. 18, my lord, their written argument. We have filed my lord written objection against the written argument, page 92.
Where have you stated that you are not, you have sought for cross-examination? You have sought for leave to cross-examine the commissioner? Where have you stated that?
Well, in the written objection, my lord, there is no stated that, but
Not the written objection. In the civil division application.
written objection, my lord, page, my lord, 92.
Page?
92. They filed, my lord, the written argument. We filed, my lord, written objection
Yes,
against.
yes, you have filed a written objection.
Against the, my lord,
Did
written argument.
Sir, did you file any objection to the report?
My lord, yes, my lord.
Show me your objection to the report.
Against, my lord, local investigation.
Yes.
Yes, my lord. Objection 59.
Page 59.
Yes.
Yes.
At length, my lord, Bengali is.
No, this is application, objection against the application.
Yes, investigate, local
No,
investigation.
I want to know against the report. Where is your written objection against the report?
Report, my lord.
What is your name?
69, my lord.
You are the defendants.
Yes, defendant number 1.
Defendant number 1.
Yes.
Yes. Page 77 is your objection to the report.
77 page.
Yes.
Para 4, my lord, kindly see.
Sir, you have not examined the commissioner.
No, Sajja minute.
You have not examined. Kindly come to page 81. What is page 81, sir?
Cross examination.
Sir, you are saying, I was under the impression that you have not, you have annexed that and you are saying, Ashun, this application-
My submission 17, Lord, I am appearing for the petitioner.
Yes.
May it please your lordship.
Yes, sir.
Lord, petitioner before your lordship is a defendant, sole defendant and tenant in respect of Lord suit property, Lord, by a rental of rupees 150, Lord, payable according to Indian calendar month, English calendar month. Now, Lord, the suit was filed, ejectment suit was filed by the transferee landlord opposite parties, they are the plaintiffs, Lord. And, my lord, after purchase, they have attorned the tenancy, my lord, and according to attornment, there, my lord, 10,000 rupees has been given adjustable advance rent, my lord. Thereafter, my lord, the suit was filed, and in the suit, my lord, the petitioner, the defendant, Lord, filed an application under section 7(1) of the Premises Tenancy Act and 7(2) of the Premises Tenancy Act. Lord, 7(1) he has gone, she has been paying rent, Lord, month by month, current rent, and 7(2), my lord, with regard to area rents. There the dispute started, Lord. And, my lord, the two calculation has been made, Lord, in the 7(2) applications, and order has been made. And the petitioners, Lord, gone to Lord deposit the rent, but the department did not accept that rent because of the fact there is a miscalculation and wrong calculation of arithmetical error. So, my lord, for correction of arithmetical error, my lord, an application under section 151 was filed before the learned chief judge, my lord, Small Causes Court, Calcutta. And after, my lord, hearing the application and, my lord, after calculation, the mistake has been driven out. And, my lord, the fresh, my lord, the calculation has been made. And, my lord, the petitioner was directed to deposit that. But the order, my lord, in the order, the deposit has not been made. That is why the department raised a dispute that the order has been passed, but the no deposit has been made. So another application 151 was filed before the learned chief judge, my lord, for depositing calculated area rents. Now, my lord, that application was pending, and thereafter, my lord, the application was transferred. My lord, the entire case was transferred to the fourth bench of the Small Causes Court at Calcutta. And there, my lord, now your lordships kindly come to the impugn order. Last order, my lord, the passed by the learned judge, fourth bench. There, my lord, the point raised, my lord, by the learned judge, my lord, holding inter alia, that as he is a, my lord, subordinate judge of the learned chief judge, so he has no jurisdiction or power to, my lord, recall the order or to, my lord, correct the order or to give direction to deposit the rent.
Where is your application?
My lord, application, that application to page code.
Application for correction, where is that?
Application, my lord, page 27, my lord. Page 27. Huh? Lord, and page 27.
No, are you complying with section 7(1)?
Yes. 7(1), Lord, I am complying.
The learned trial judge held that the defendant failed to comply with the provisions of.
No, no, Lord, there is a pandemic situation that is some disturbance was. That reason,
So if there is any default in 7(1), unless that is cured, no use directing you to deposit, because defense can be struck out under for failure to comply with 7(1) also.
Yes, yes, that's right, Lord. Your lordship is perfectly right. That should be corrected.
Then,
Lord, your
no
lord,
use directing you to deposit if there is failure to comply with that.
Yes.
That is cured. So how can this be directed? It cannot be permitted to deposit, even if that is not seen.
Lord, the learned passed an order was
But 7(1) the default remains. That has not been cured. This 7-2 order has been corrected, as you have rightly said, but 7-1 default still remains.
Yes, 7-1, Lord, 7-1, we have, but the disturbance was there, Lord, that is why.
That you have to take out an appropriate application. Unless you take out that, the defense automatically will be stuck out.
Then, Lord, your lordship kindly give me a leave to file that application before the learned judge.
I'm not doing anything. Do whatever you want. I'm only adjourning this. I'm adjourning this, keeping it in the next monthly list.
Only
steps in the meantime. Otherwise, there will be a difficulty. I'm keeping it in the list. Take steps in the meantime.
Yes.
The learned advocate, after some argument, the learned advocate. Otherwise, it will be a difficulty.
Lord, in the lordship kindly give me this leave, the correct amount of internet.
Application, without the application, you cannot be permitted.
Yes, that we will file. Yes, that we will.
That application.
Lord, only I am saying on the Lord, so isolated range of the children.
These text steps, they are passed. Then come. I've kept it pending. I have not said anything. Yes, call the fixed matters.
No.
On fixed matters. Item number 350.
I'm getting to Lord.
Thank you, sir.
Item number 350.
350. None appears for the petitioner at the time of call. No accommodation. (351), same order.
352.
Same order.
353.
Same order.
354.
Same order.
55.
Same order.
356.
Same order.
357.
Same order.
58.
Same order.
59.
Same order.
360.
360 my lord, I picked to.
Petitioner. Yes.
It was passed in the year 2000.
Anything left, Mr. Chakraborty?
Left means, my lord, the majesty of the court, my lord. The thing is this, there was a specific direction to, my lord, the chairman of a particular, my lord, municipality.
Have you served? No.
Right now. Right now, my lord. At
No.
stage.
This application was served.
Yes. Yes.
When
my
did you serve?
The other details have to be collected, my lord.
Nothing. 2013, we have not taken any steps, even for mentioning.
No, my lord, because of the
You have collected it from the department. Now you are saying.
only thing, my lord, the thereafter.
What is the order in?
Rajarhat municipality merged with the, my lord, the Vidhannagar Municipal Corporation. Since then, we are talking with the negotiating with the Vidhannagar Municipal Corporation. Matter is pending. Lordship knows on one or two occasions, Lordship heard this matter. Each and every tower, one unauthorized construction.
That is so. That matter is pending.
Pending.
That is the read.
This is one.
So what happens with the content? Nothing remains. Proceed with that.
Yes, sir.
Asun. Hard. None appears. Dismiss for default. Next.
Item number 362.
Dismiss for default.
363.
Same order.
364.
Same order.
365.
Same order.
366.
Same order.
367.
Same order.
368.
Same order.
369.
Same order.
370.
Same order.
371.
Same order. T72. Same order. T73. Same order. T74. Same order. T75. Same order. T76. Same order. T77. Same order. T78. Same order. T79. Same order. T80. Same order. T81. Same order. T82. Same order. T83. Same order. T84. Same order. T85. Same order. T86. Same order. T87. Same order. T88. Same order. T89. Same order. T90. Same order. T91. Same order. 92. Same order. T93. Same order. T94. Same order. T95. Same order. T96. Same order. T97.
Lordship, 397.
397, yes.
Lordship, there was a direction by Honorable High Court uh, to service to supply a certified copy of this land by BLRO. But
Yes.
BLRO was don't complied the do not complied. Hence we have filed this present contempt petition. Now, Lordship, present contemptor.
You have not got the copy till now. Have you got? You have not got certified copy.
Certified copy? I have not got.
You have not got?
No, no, Lordship. No, now Lordship contemptor was changed. The new contemptor is incumbent. So, Lordship, I kindly give me time for amend contemptor name.
Amending again, it will not come. I am giving you liberty to file, since the contemptor has changed, to file a fresh application. Ashwin. This application under article, this is an application.
Scale of pay, higher scale of pay.
Yes.
Honorable Justice Rajiv Sir may passed an order directing DI is change only
Yes.
to give me opportunity to
Higher scale of pay. Now the judgment has come. So you apply in terms of that judgment.
No.
What remains? What remains?
Order passed, page 20.
Yes. What is the order passed?
Order passed accordingly without entering into the merit.
So to pass a reasoned order.
It is not.
Yes. So now the larger bench
Right.
has. So I'm giving you liberty to file a fresh application, representation that will be considered. Nothing remains in this.
Order is still in force. Order is still only page.
Sir,
20.
order is still in force. This order was passed in 2017. Now the larger bench has passed an order. So file a fresh application on the basis of that. Ashwin, this Same order. শুধু দেখে নেবেন এই অর্ডারের ডেটটা। Yes, next.
Item number 400. My lord, I have got the petition on my lord.
Yes.
My lord, this order has not been till let complied with.
Yes, what is the order?
Order is the matter, land acquisition matter, money has deposited to the Larnet district judge Paschim Medinipur. That times two Medinipur had joined, but so many battles has been fight between the private respondent and the petitioner. The matter is ultimately settled to the High Court, but the matter has not been settled by giving the money to the petitioner, my lord, about 10 lakhs rupees, my lord. My lord, the impugned order 19. In the meantime, my lord, the container has been changed. The new encumber has come.
Yes, so you have to communicate. You file a fresh representation.
No, my lord.
Annexing this order, I will direct that to consider that.
My lord,
Otherwise, the new incumbent has come. No one knows where are the documents.
I have communicated the order.
The new incumbent you have communicated when? That is in 2017. Today we are in 2025. Can those records be located? That's the difficulty. Ashun.
The difficulty is, my lord, the petitioner is not in India. He has gone going to the son. That is, he stay at America now.
Yes. Petitioner is not interested there. Petitioner is not interested. So I'm not fixing any time limit.
Money has not been withdrawn by the petitioner.
All right. I'm giving you liberty to file a fresh representation before the present respondents because the contemners have changed.
If we correct the present container, that is no difficulty with that. And then I will serve the copy of the.
Have you seen the name of the first contemner?
Yes.
Have you seen?
No, yes. That is Vivek Chaudhary, I have seen.
So none of the third contemner. Do you know the present position of the third contemner?
Third container, I see.
Do you know the present position of the third contemner?
Yeah, the change.
So,
but kindly
no records can be located now. I'm giving you liberty to file a fresh representation.
One time, I will intimate my client that he will come back. That's the.
Yes, do that after he comes back. This application.
similar matter.
Higher scale of pay,
Higher
এই
scale
higher
of-
scale of pay যে অর্ডারটা হয়েছে না, higher scale of pay যে একটা অর্ডার করলাম ওখানে। What is the other matters? 398.
398, 399 হয়ে গেছে।
398,
401.
399 এর মতো। Yes, 401 same as 398.
Same.
Yes, what is last? Yes.
Within certain period.
You file that, it will be.
It does. Item number 400.
I am for the petitioner, my lord.
Yes.
Lord, the defendant is the applicant before your lordship, my lord. My lord, I am suffering an order whereby, my lord, the plaintiff's amendment application was allowed, my lord.
Yes.
My lord, here what has happened, my lord?
The suit for.
My lord, the suit was originally only for injunction, claiming that the plaintiff is in possession of the premises. The suit was filed in 2018. In 2018, I filed written statement and objection to the injunction application filed by them. In my written statement 2018 itself, I disclosed how I derived title and I am in possession of the property. Their injunction application on contest 2024 rejected. After rejection of the injunction application in 2000, at the beginning of 2025, they filed an application amendment seeking amendment, wherein, my lord, they are claiming that they are the owner of the property. Now, my lord, on what basis they are claiming the ownership of the property? That, my lord, the suit property, my lord, originally was owned by.
Show me the amendment application.
My lord, my lord, the amendment application, my lord, is appearing at page 51. Page 51 of my application, my lord. It starts from page 51. My lord, paragraph 4 to 8, my lord, I have real objection, my lord. Because this, according to me, changing the nature and character of the suit entirely. Schedule of amendment is at page 55.
Which paragraph you are objecting to?
My lord, kindly take the schedule of amendment, my lord.
Yes, I'm
Page
at the
55. I have real objection, my lord, as regards to 7C, 7B and 7C. Because two principal objections. These are barred by law of limitation, this plea, because he had knowledge since inception. And second, it is changing the nature and character of the property. And third, even if although the amendment is allowed, relief cannot be granted because these are not parties to the proceeding. So no relief can be granted even. He is challenging my deed only that was executed in 1997. I got the title from Urvashi.
the issue that arises I can expedite the, you deposit the amount,
Yes,
I will expedite. Those
Expedite-
you will deposit the amount, I will expedite. Item number 20.
Expeditious disposal, your lordship.
You are for the petitioner.
I'm for the petition.
Expeditious disposal of what?
Order 39 Rule 1 and 2 application. This particular ex parte order was passed on 12th of December 2021. Thereafter, your lordship, we filed our written objection, your lordship, and the written statement. Thereafter, we filed an expeditious disposal application earlier also.
Injunction application is still pending.
Still pending. Page 56, your lordship kindly sees there is an order passed by the Honorable High Court for the expeditious disposal within 3 months from the date of the communication. This has been noted by the learned trial court on 18th June 2024. Despite your lordship the recording, your lordship the order 39 rule 1 and 2 application has
Sir,
not
it
been
cannot be done. The suit is, service is not ready. And we have obtained an order of injunction.
Lordship, I have not obtained. The ex parte identity order
You have obtained an order for ex parte hearing, expeditious hearing.
expeditious disposal.
Summons has not been served.
But no, regarding the suit, your lordship, the summon, your lordship, the plaintiff is required to serve the summon, but your lordship, all the parties are appearing. The learned court, your lordship, has heard the matter, but is not passing the
Does
order.
not appear, all the parties are appearing.
Your lordship kindly
Service
sees.
returns,
Lordship kindly sees the last order.
service returns of the defendant number 2.
No, one and lordship kindly sees the last order.
13th of June 2025. 11th of July 2025 for further hearing of the injunction petition and service returns and AD 40.
Lordship kindly take 29th April 2025's order.
29th.
They appear in piecemeal basis.
So what can be done? No directions can be
Lordship,
passed now.
kindly take your lordship 29th April 2025's order, page 54. All parties are appeared right now.
29th of April, no. SRN AD. Defendant number 4.
SRAD, but thereafter your lordship the kindly sees every day he is fixing the matter for hearing of
Has to
injunction
be.
application.
Nothing can be done.
But your lordship kindly sees the orders in sequence.
This application under Article 2.
I am
number 2 is not appearing and you are 4 to 5. Sir, how can it be done?
My lordship, kindly understand one thing, lordship, what has happened. I am the owner of the property. Kindly appreciate one thing. What he has done. My property, he has shown your lordship that.
Sir, the application for injunction.
Lordship, kindly clarify that this particular order of injunction is what has happened.
There.
Lordship, kindly appreciate this property belongs to me. 75 katas of land in Tangra.
set up people, your lordship is,
Show me the order of additive injunction.
lordship kindly take page 25.
Yes.
They want your lordship this litigation to be there so that I cannot deal the property. That is the main motto. I am the owner's 75 cutters of land. These people are fighting or set up people, get an order of injunction. So the property is litigated. I can't do anything.
Yes. This application under Article 227 of the Constitution
Now the problem is, your lordship, he has appeared. That particular person, defendant number 3 has appeared.
3 has appeared, but 2 has not appeared.
And 2 is the wife of the 3.
Yes, take steps. You have to take steps, sir.
I am the defendant, your lordship, unless and until the
I'm not-
plaintiff takes
I'm not-
steps.
I'm not asking you to serve. I'm not saying that you have to serve summons. There are ways and means. You have to apply those procedures. Yes, next.
Item number 21.
Lordship, this is my application, Your Lordship. This matter relates to the matrimonial suit, Your Lordship, for expeditious disposal of this case, Your Lordship.
Who are you?
Lordship, I am for the husband petitioner, Your Lordship.
What is the stage of the matrimonial suit?
Lordship, this is in the evidence stage, and the next date is on 25th July of this month, Your Lordship, this year. And this.
Any alimony, direction for alimony has been passed?
No, Your Lordship, no, nothing as such. Neither the wife preferred. In any other cases or like that. Your Lordship, in this case was filed in 2021, Your Lordship, in the month of April. And after lapse of 3 years, the other side filed the WS in this case. And several times there was ex parte. On a number of times they will change the advocate, and every time they will file new wakalatnama, and the case will is lingering day by day.
This application under Article 227 of the Constitution.
Be fixed for
Evidence,
expeditious.
expeditious hearing it will be done. Yes. Since I'm not inclined to take up this matter on.
Lordship, I am in correspondent number 1 in this matter.
Yes. Yes, Mr. Mundal.
Yes, my lord, by the impugned order, my lord, by the tribunal, my suit for specific performance, my lord, has been dismissed.
Please use the microphone. Yes.
My suit for specific performance has been dismissed, my lord.
Suit for specific performance.
Lord, I have prayed for renewal of my lease. My plaint is at page 40.
Where is your prayer?
Prayers are at page 59, my lord.
You have not sought for specific performance.
No, my lord. I have prayed for declaration to the extent that
is it
plaintiffs are
sufficient?
entitled. No, my lord, they are
Unless you pay for specific performance.
No, my lord, I have prayed for declaration to the extent that I. Let me show that.
Yes, Mr. Rai. Specific performance not prayed for. Mandatory injunction will suffice.
Subject matter of dispute before your lordship. Subject matter of dispute is pending before your lordship. my lord, is of the opinion that amounts to, my lord, the court is a court fee.
Yes, yes,
Only for the purpose of court fee.
yes.
My lord, can direct us to deposit court, we will deposit the same.
Suit has been dismissed now.
That is why. What is the reason for dismissal of the suit? I put this question to myself.
What is the reason?
Yes. If your lordship can turn to the agreement which was executed between the parties that your lordship find, can you turn to
Page 27.
page 27?
Page 27, yes.
I am drawing lordship attention on
No, show me the reasons. What is the reasons assigned? by-
only page 35.
Page
Clause F. It is the main
5.
clause F.
Clause F, yes.
This is the if after expiration of the terms hereby granted, the lessee shall be desirous of obtaining a renewal of this lease, and office such desire shall deliver to the lessor notice in writing not less than 3 calendar months before the expiration of terms hereby granted. If there shall be no subsisting breach of any of the lessee's covenant or an obligation under these presents, then the lessor shall, at the cost of the lessee, grant to lessee a renewal of this lease for a further term of 10 years at a rent of rupees 2,600 per month, and on the same terms and conditions are therein contained in the present covenant, renewal expected. Pause there for a
When
moment.
this lease expired?
It is 2016.
2016. And
Extension 10 years, 2026. Yes, I read it. Let me say.
where is your letter
Yes.
for extension?
Lordship, I beg to appear on behalf of the Board of Work.
Yes.
Submitting the order passed by the Supreme Court.
I will come back to you. Yes.
It requires consideration as well. Our senior friend is placing the Supreme Court judgment. My lord is.
Yes, 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 yes.
On this one.
Now, my lord, can you consider the letter? It is admitted the letter was sent.
Yes.
In the
Now, what is the ground on which it was
Yes.
rejected?
Now, ground. What is the ground, my lord?
Show me that reasoning of the learned judge.
Yes. If your lordship can turn to internal page 22 of the order impugned.
Yes.
It is found. Well, consider third paragraph from the top.
Yes.
The plaintiffs have sublet the part of the lease property to different person against whom the encroachment procedure is drawn up by the Board of Work-off. Needless to mention that the plaintiffs have patently violated the terms and lease by subletting the part of the suit property or to different persons in lieu of money. It is also found the plaintiffs have constructed building without sanction plan approval from the Mutwali or Board of Work-off. The claim of the plaintiffs that Mutwali defendants has lost the previous suit is not accepted here because the plaintiffs have not filed any document to substantiate their claim. Therefore,
Mr. Rai, if the previous 3 paragraphs,
yes,
if that is there, you have sublet and you have done this violation, so that is the ground for
yes,
non-renewal.
that is why one can turn to the. If that be so, the claim of the plaintiff Mutwali has lost the previous suit is not accepted here because the plaintiffs have not filed any document to substantiate their
That's a
claim.
different thing altogether. But
This is the ground based on which the earlier suit was filed.
yes,
The suit was dismissed. Then, my lord, what will be the fate of those proceedings? The findings.
plaintiff means you have filed.
No, it is the Mutwali.
The claim of the plaintiff that the Mutwali defendant has lost the previous suit is not accepted here because the plaintiffs have not filed. Yes, you could not substantiate. That's your only submission. You have not produced any material.
Merely by taking money to the lesser does not mean the.
Yes. What's the wrong in the finding? Mr. Rai, because there is a specific finding that you have sublet and the renewal clause says if there has been no subsisting breach of the lessee's covenants and if there is a covenant restricting you from subletting, how can you claim renewal?
Yes.
If you cannot overcome this finding.
Based on once can you consider the evidence? What are the documents before the learned tribunal for whole came to such finding?
Yes.
Where
are the documents?
From the, it must be reflected from the impugned order, my lord.
Yes.
Can you consider impugned judgment?
Show me.
Yes. Internal page 5.
Internal page
5.
Yes.
This is the statement made by the defendant. I got it?
So 5 is all plaintiffs' averment.
No, last. 5.
It is also laid by the defendant. Plaintiffs are deemed to be
It
encroached.
was laid down by the defendant, the plaintiffs are violated. Now it's one paragraph.
Yes.
Paragraph 11. 11. Page page 8 7 থেকে ইয়েতে শুরু হচ্ছে 5 থেকে শুরু হচ্ছে হ্যাঁ আমি জর্শাকে বলছি না না ঠিক আছে কোনো অসুবিধা নেই now if you logic I turn to page 11
Page
11
yes
kindly mark these two exhibit number 5 and 6.
Exhibit number 5
and 6.
Yes.
Now, my lord, can you consider issue number 3 and 4? What is the issue number 3 and 4? My lord will find issue number 3 and 4 is the deed enforceable under the provision of Walk-off Act. Issue number 3, 4 is plaintiff entitled to extension or renewal of the suit list. This is the issue number 3 and 4. The parties are dragged down to concerning the issue whether the plaintiffs are entitled to cardinal relief. The parties are also aggressive regarding issue number 3 and 4, whether plaintiffs are entitled to renewal of the lease after expiry of 51 years. On perusal of the record about scanning pleadings, documents, it admitted the agreement has been terminated.
Yes, yes, Lordship.
It was determined earlier.
Internal page 18.
Yes, I'll come to that.
These are the exhibited documents.
Yes. Then
you are a defaulter. So for that it was terminated.
Yes, Lordship.
Manor is so fast, Manor.
No. I'm only going through some of the pages.
Yes.
Something is catching my eyes.
Is also impact of time the lease expired on 2016. Admitted the plaintiff and the defendant are bound by the terms and conditions of the lease. The point adjudicated whether the plaintiff's claim and prayer as laid down in the body of the plaintiff has merit or not. Peter Pradut Mondal corroborated his plaint facing the dock and subject his cross-examination with the contesting defendant. Judgment gulo. He admitted that he did not testify, skip the he deposed as well as ever the fact.
Sir, I will hear you. I'm fixing this matter because
now, my lord, can you consider? So termination was there, and the Supreme Court judgment.
Yes.
Supreme Court judgment.
I have annexed.
Yes, what Supreme Court judgment?
Termination has to be dismissed for non-prosecution.
এই যে ওটা ইয়ে কত 142 of 1999 এক মিনিট দাদা
এটা হচ্ছে আমাকে সাবলেট করতে হবে এর আগে ছিল
কোথায় গেল এই
না ওটা যে রিনিউয়াল এই ওইটা ওই সার্টিফাইড কপি
পেজিনেশন করিস না কেন
Yes, have you deposited this 3 lakhs?
Yes. We have deposited. And so the my lord is asking regarding that age. And what is the fate of that suit for?
No, this is the SLP arising out of which order?
Revision. Here, my lord. Appointment of receiver, which is subject matter of challenge.
Now, Mr. Rai, if you have deposited this, and the direction was that if you deposit, you will be entitled to retain possession.
Yes, we are in possession.
Retain possession.
Yes. And what is the effect of that suit? Is followed from your lordship regarding the non-payment? The issues proceedings was initiated.
Mr. Rai, what more do you want after the Supreme Court judgment? There is nothing.
No, there is a suit.
What remains? The Supreme Court has allowed you. You have a right to stay. Your possession.
Latter portion.
More.
Latter portion, my lord, up to the it is or ventilated all the grievances before the tribunal. My lord, can you consider that?
Yes. But Mr. Rai, you cannot claim beyond August 26.
No.
That's the point.
So Mr. Rai,
whatever
it is, you want protection up to August 20.
Yes.
So the Honorable Supreme Court has protected you. Nothing remains.
Your logically restricts by up to August 2026.
Yes. So that is the Honorable Supreme Court has said why there is no necessity to further rest.
But they are issuing the ejectment notice.
Mr. Rai, you are protected by the Honorable Supreme Court's order.
Can you run to page 98? What will understand?
And Lordship, if they are ventilating that in section 54, that is a separate proceeding. No, no, dispute position enjoy করুন।
Page 99.
No, this is the encroachment of the same property.
Same process
How
initiated.
can you do this? If they have paid this amount, they have been allowed to remain till August 2026. How can we issue this?
We have not, we had started the proceeding, now the proceeding.
So I will record your submission and I will say that they have paid, they are protected, so they will remain in possession. And I will record your submission that this.
Lordship, it is already there in 2026. the Supreme
Twenty
Court.
twenty-six, August 26.
226. August 226.
What, Your Lordship?
And you are now proceeding with the inquiry notice.
And if so, that is a separate proceeding, totally a separate proceeding. And,
No, sir, they are protected. Maybe separate proceedings, but you cannot disturb their possession with
And
regard
they are
to
also
this
party.
property.
They are also party in that proceedings.
Cannot disturb their possession with regard to this property.
They have to pay monthly, provided if they are paid.
No, this
lakhs per
direct
month.
depositing.
Yes.
Per month we are depositing.
No, where is the provision? There is no provision for monthly amount. Where is the provision?
3 lakhs.
No, 3 lakhs, oh, per month.
Per month. Yes, yes.
Till they are in position. Till they are in position.
So you are doing that?
Yes, yes.
No.
No, Your Lordship, on the
Till the disposal of this. After that, they have stopped.
Yes.
Till that date.
3 lakhs.
Here is the payment.
File an affidavit. File an affidavit and keeping it next week. File an affidavit that you are complying with this order.
let them.
Let them.
Till we have deposited 3 lakhs with the tribunal after dismissal of my suit.
Then they have stopped.
Till deposit.
Then they have stopped.
Deposit.
Till when you have deposited?
Till the passing of the degree. Till the date.
passing of the degree.
Yes.
File an affidavit.
Yes,
to
yes,
that
yes.
effect.
Certainly, we have annexed the challenge.
Your Lordship, what about the remaining?
And where they will now deposit. Suit has been dismissed. Where they will now deposit.
They always have an option to deposit in the Waqf tribunal fund. After this process.
After dismissal of the.
All right.
They can.
So, or pay to them.
What is
Yes,
the
pay to.
You paid
Pay to them. Mr. Rai, you want extension of that period of the lease.
And you
Yes. The lesser. So they are entitled to that. Pay it to them. 3 lakhs per month.
Anywhere. Anywhere, my lord will direct, I will pay. But not the board and the.
Lordship, the area is 7.5 acres of land in Bangladesh.
Anywhere. We have already deposited.
Found by the Honorable Supreme Court's order.
They are affidavit produced.
When this
Let the bunch of document handed over be kept with your lordship's record. The bunch today, my lord, handed over to your lordship.
Take it back, file it on the next day.
But your lordship may mark it, not let it
I've
remain.
not marked anywhere. Yes, next.
Great.
That will also help you if there is any marking.
My lord, I am for the
Answer the queries on the next day.
My lord, I am for the petitioner in 24, my lord.
Yes, yes.
My lord, this is my application for expedite hearing of the my lord, matrimonial suit. My lord, pending before the my lord first track.
Who are you?
I am for the petitioner husband, my lord.
You are for the husband or the wife?
No, I am for the husband, my lord. I filed the suit, my lord.
Where is the any order passed on the alimony?
Alimony, my lord, passed, but we are regularly paying rupees 20,000 per month, my lord. Regularly.
Application under Article 227 of the Constitution of India.
On behalf of the petitioner husband in the trial court. Now, this is a case of matrimonial discord. We have filed for divorce under section 27 of the Special Marriage Act. The wife opposite party has appeared on the 13th of January 2025. Since then, she has been continuously praying for adjournments for filing of written statement. So we have prayed for expeditious disposal of this matrimonial.
Any application for alimony?
My lord, in a suit of Special Marriage Act, they have filed an application of 24 under Hindu Marriage Act without any application for stay.
This application under Article 227 of the
Lordship, I'm for the petitioner, Lordship. An application for eviction of a license and recovery of caste possession has been filed by this petitioner, the plaintiff in the suit, Lordship. The title suit number 567 of 2016.
Yes, what is the impugned order? What is the order?
Lordship, it's
under
an
challenge?
expeditious hearing, Lordship.
Expeditious hearing.
Yes, Your Lordship. It's pending since 35.
Eviction suit.
Eviction of licensing and recovery of
What is the stage of the suit?
Lordship, yet application under order rule 6, order 6, rule 17 is still pending, Lordship, and evidence has not been started yet. They have filed a written statement and written objection. Previously, an application filed by them under Order 39 Rule 7 has been allowed
Order 6 Rule 17 filed by whom?
by the petitioner lordship. On
You have filed.
yes,
What is the next date fixed?
next date lordship. The last date was 18/6/2025 lordship.
Yes.
The next date it's not there.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff. Maybe there will be a challenge. Yes, next.
Item number 27.
Yeah, Mr. Bhattacharya.
Since I'm not inclined to take up this matter on personal matters.
I pay for the petitioner. My under challenge, my lord, is an order of 2nd June 25, my lord, passed by the District Consumer Forum in an execution proceeding. Lord, kindly seize the order for once, my lord. What a the perverse order that has been passed, my lord.
It's not an appellable order.
My lord, I have judgments, my lord, that the revisional court, my lord, can, if it's a perverse order, my lord, kindly seize the order just for once, my lord. It's a 4-line order, just seize the order, my lord.
Order dated?
2nd June, my lord.
Who are you?
My lord, I am the stock exchange judgment debtor number 6. I have been asked, my lord, to pay jointly and severally, my lord. But that's not the issue, my lord. I am on a very
This order 2nd of June.
My lord.
Your prayer for adjournment was allowed.
Yes, my lord, I have been directed to be personally present. The stock exchange, my lord, I have filed an application challenging the maintainability of the execution, my lord. But I was only beseeching your lordship, if your lordship kindly passes a direction that may be taken up prior to deciding of the execution proceeding. That's all I am seeking, my lord. Maintainability, my lord. My application is at page 55, my lord. My lord, I am a stock exchange. I am a facilitator, my lord. I have been directed to pay jointly and severally the compensation.
Why did you pray for adjournment?
But what has happened, my lord, now in the consumer forums, my lord, we have to file the application in a two-way process, my lord. One by a soft copy method, my lord, one by the physical copy.
What is the next date fixed?
Our next date is fixed in August sometimes.
16th of August.
But only the maintainability application, my lord.
You serve and come back.
Well, then I'm praying for a short stay. But 2nd of August is the next date.
2nd of August, nothing will happen. Because
but
of
personal appearance. So, my lord, same matters.
32.
32, my lord.
32.
Yes, same order, my lord.
32, same order.
Same.
30, 31, 32. Separate order, same order. Yes, next. Call the next matter. 33. 29 টা হয়ে গেছে?
29 টা হোক।
29.
Lordship,
Item number 29.
Lordship, my senior Anjan Bhattacharya.
I'm calling for you.
Sorry, Lordship, my senior Anjan Bhattacharya for the respondent number 6 to 11.
Who is that?
Anjan Bhattacharya. I'm praying for only not to the Lordship. Lordship, Lordship, he left the court some personal difficult.
Convince Mr. Basu. He is opposing.
Kindly lordship,
Building, I cannot.
but kindly lordship, make it only not to lordship. Tomorrow he appear in the matter. Lordship can't.
Let them assure they will not be demolished.
Lordship can't.
Who are you?
Lordship, I'm the opposite party number.
You the complainant. Which municipality?
Not.
Who is appearing for Dom?
No caveat. Dum has not left any.
Sir Basu, there may not be any caveat. Who appears for Dom municipality? You don't know, Mr. Basu.
South HON'BLE is right.
Dom municipality? Who appears? Please bring, otherwise
Well, I can,
difficult to implement.
when they 1 minute, well, I can convince my lord.
Not what is the order impugned? What is the order
Kindly
impugned?
see the order of demolition which has been appealed against under the statute. So your lordship did not see that order. Kindly see the order
Sir Basu, the difficulty is in matters when I want to see the demolition order, says no, please kindly come to the impugned order. Now, yes, now you are trying to show the impugned order.
My lord is,
please show me the impugned order first.
my lord's, from my lord's body bail of advocate is still community. So my lord will not say this. Kindly come to 310. Then I will go. I will not, my lord.
Mr. Basu, ask your one of your juniors to inform the advocate who is appearing for Dom.
No. HON'BLE for the South Dom I know. Janice Sorry. But kindly see the top. This I will place.
I think you are aging, Mr. Basu.
No, that once upon a time I used to know everyone.
That is why I am telling you, you are aging.
That is normal rule.
Yes, 310.
310.
Yes.
See what is this? This is the minutes of the meeting. Am I clear to my lord? This is not an order communicating demolition order which has been taken by the Board of Councillor. This is a meeting supposed to be taken in the Board of Councillor. Who has signed this? Chairman. First ground, order cannot be seen the light of the day, cited by judgment of your lordship. Secondly, my lord, this order does not have any sketch map which part is required to be demolished. Second part. Third, the learned lower appellate court or the first court of appeal passed an order of demolition.
Who are you, Mr. Basu?
I am the owner of the property.
Owner of what?
Property.
No, the demolition is with regard to the garage.
226.3.
Car parking space, covered car parking space.
Everything is there. The finding, what I am saying, finding here, everything is there. But who had passed this order? Bengal Municipal Act. Kindly come.
No, what has been directed to be demolished? Covered car parking space in place of open car parking.
Area of unauthorized construction is 226.301 square meters. Has Maharashkali got it? So this is according to the municipality. This is the deviation portion.
Show me your, you have purchased.
No, I am the promoter and owner, both.
You are the promoter?
Promoter and owner, both are.
Where is the sanction plan?
I will satisfy. Kindly see who is passed this order. Who has passed this order?
Yes, I will come to that. Please show me the sanction.
No. I am saying there is the deviation.
There is
deviation. There may be deviation. There may be deviation, not without sanction plan. Two cannot be seen in the same category. One is without sanction plan. When is it?
Mr. Basu, it says that a covered car parking space, yes, I will come to that. In place of open car parking, position of the septic tank and UGR has been altered. That's the finding.
No, ultimately.
And what is the impugned order? Show me the impugned order.
Coming to that. Before that, Mano, let me satisfy Mano. The order which has been appealed against or the statutory appeal was carried out is non-est in the eye of law.
So you want me to decide the appeal?
Appeal has decided. Appeal has been decided.
Appeal dismissed?
Yes.
I was thinking the interim order.
Now that's why, Mano, kindly once refresh your lordship.
That is why I asked you that what is the impugned order? You are not taking me to that. I was under the impression that's the stay order.
I will take your lordship if necessary. Bengal Municipal Act dena. But kindly refresh your lordship memory. 218.
Where is the judgment?
So everything I have. And that judgment by many means cannot be altered by mine. Can you see 218? The Board of Council is satisfied. Can you see who has passed the order? And this is not the communication. It may be said that the Board of Council has passed an order, chairman has communicated. This is the minutes of the meeting. There is no sin of any Board of Council.
Where is the,
This is the first one. This is the first point.
no,
Order passed.
show me that tomorrow it will be demolished. Where is that?
Court has passed an order of demolition. Who is the court cannot?
No, where is that? You are saying that tomorrow it will be demolished.
Certified copy?
Certified?
Certified copy of the order.
Certified copy of the, which order?
Order, this tribunal's order means district judge's order.
Yes.
Civil judge junior.
No, that was dismissed.
No, had it been dismissed only, I could have understand. Aste.
1 month.
Number 1 and 5 are directed to comply. Order dated such and such and submit a report within 1 month from the date of passing of this order.
Yes, 1 month is expiring tomorrow. 1 month.
Within, my lord. Every day is. Now, this has been learned by the lower courts from your lordship's court.
What?
Demolish and comply and come to me. This is not normal order by the lower courts. This is good. I am not saying this is bad. But in a case where there is genuinely, but there is an order. Take copy of them. Annex. See, kindly record 2007. There is a judgment, my lord. I don't know why he have annexed that. But it means my senior could have kicked me. Kindly come to page 328. 328.
I am used to this, Mr. Basu. Now I have got written notes of argument annexed.
Judgment annexed.
All judgments.
Completed.
Yes. Judgments also annexed.
So I got a kick from my senior by doing this.
Where is the earlier parent judgment of the division bench? This is the division bench parent judgment.
So pilot is also have done this here. When he is the Odisha judge, we should see the Odisha judgment. When there is the Madhya Pradesh judge, we should see the Madhya Pradesh judgment. Here is a judge who, my lord, my no stage of evaluation cannot say this is not a good law. That's why I bring that.
But Mr. Basu, only thing is it's the extract of that meeting.
Yes,
this is the resolution. Resolution was taken by the Board of Council.
No, this is the resolution. Before the court below, my lord, the list by Firisti, these documents was produced. Where we have taken a specific point that it has not been passed by the Board of Councillor. Reply to that, this document was by Firisti annexed. There is no evidence because it is an appellate court. And even if there is a demolition order, there should be followed by a sketch map. There is none.
There is no covering letter, Mr.
No, this has been.
Please kindly come to page 220.
20.
Yes.
This is the document, my lord, by Firisti.
Yes, please come to 220.
Yes, this is the order.
Yes.
This is annexed.
This is by the letter, it has been annexed. Board of Councillors has taken a decision in exercise of the powers after giving an opportunity to comply.
I say.
So this is the minutes of the resolution of the Board of Councillors.
Yes. This is the minutes communicated by this letter.
Yes.
But the extract of the minutes does not show that councillor was present.
Where have you stated that? Show me.
This is my specific argument before the court below.
Maybe show me that where have you stated that this decision was not taken by the Board of Councillors. It's only the chairman who has taken this decision. Show me that.
I was submitting, my lord, this communication by the chairman permissible.
No. All right. Yes. According to you, Mr. Basu, the decision has to be taken by the Board of Councillors, which can be communicated by the chairman. Yes. So according to you, it's a decision taken by the chairman, not the Board of Councillors. So show me that it's a decision taken by the.
Come to page 3.
Page
3 of the
civil division application.
Impugned order.
Impugned order.
What is the argument, my lord? The court has taken note of. During argument, learned advocate for the appellant raised various issues for which the impugn demolition order is bad in law. At the outset, learned advocate for the appellant.
No, I have not. Yes, during argument. Yes.
Legality of the order as the same is not signed by all the members of the board of council as the specific case made out.
Yes, what is the finding on this?
Finding unimaginable. Section 15. I have given yours the book.
Section?
15.
No, show me that portion.
Yes.
What is the finding?
Second portion, my lord, kindly come to 15 টা কোথায় যেন লিখলো? Kindly come to page 6. Yes, last part.
Last?
Last before order, that page stop.
Yes.
Is bad, it does not contain the signature of all the board of council. Section 15 of the West Bengal Municipal Act provides that the decision of the board of councillors shall be communicated through the chairman who shall preside over the meeting. I have no dispute about that. And 15 also has not said so. Communication, I have no problem.
আমি নিজে প্রেজেন্ট ছিলাম সবাই আমরা একই করতে পারি না সকালবেলা বাড়ি ভাঙা আটকে বাড়ি ভাঙতে পারছি
আপনি তো একটা বাড়ি ভেঙে 2 নম্বর করে 26 নম্বর করে বলেছে
পিটিশনটা স্যারের কাছে দেওয়া যায় আপনি স্যার একটু পিটিশনটা দেবেন একবার পিটিশনটা দেবেন
Item number 33.
It was a faint recollection, 2000, volume 1 or 2 CL.
Know that. I thought that is there. I find Justice Bhattacharya's judgment comes little more effective.
That is the parent decision, 2000 volume 1 CL.
May I take the
Yes.
For you, item 33, this is expeditious disposal of the title suit, Lordship, 2010 title suit. Suit for decree of permanent injunction, Lordship, pending before the court of the learned.
This application under Article 227.
I am for the petition, but I am praying for an adjournment of 1 week on the ground of Mr. Buddhadev Ghoshal, he is the senior advocate appearing in this matter along with me.
On the prayer of the learned advocate for the petitioners, hearing of the civil.
Monthly list. Item number 550.
Yes, my lord. In this matter, I am for the petitioner. This is a revision for expeditious early hearing of the 7172 application. Defendant filed the application 2nd November 2019. That application is pending without pay admitted area rent. And in the after that, your petitioner filed a 73 applications till now.
What is the next date fixed for hearing?
9th September.
9th September 72.
7172 and 73.
How can all the same be fixed on the same day? Unless 7172 is decided.
They did not pay the admitted area rent.
6-1, my lord. I am for the petitioner, my lord. Petitioner's disposal matter, my lord.
What?
My lord, of the suit, presently when I filed the suit, it was
Have you
as
served?
yes, your lordship. This was my affidavit.
That is the evidence service.
Yes, this is the affidavit of service, your lordship.
This application under evidence service file. Yes, none appears for the petitioner at the time. Yes. Yes. Yes, Mr. Basu.
Yes. The point is, according to me, is not very complicated. MSME as a category, who can be termed as registered as MSME, and with the registration of MSME, the nature of business which is most now, nature of business which they are doing is annexed.
Is
annexed with that registration. What type of business he is doing? Question cropped up before my lord. The day I entered into business deal with that MSME organization, on that date he was not registered to that type of business. I repeat, MSME registered. No doubt.
No, I follow. On that particular date, he was not registered for conducting certain that type of
That type of business is not there.
in the registration certificate.
Secondly, it was inserted. Whether that company vis-a-vis me is subject to MSME and the summary proceedings can be initiated against me.
What is the summary proceedings? Conciliation.
This MSME has a self-concept code how is to be done for benefit.
So, what is the impugned order?
Impugned order is, my lord, the award and the execution. Yeah.
Award means arbitration award or the conciliation.
Conciliation.
So, conciliation.
But for that registration, he cannot be under MSME. So, but vis-a-vis me.
But you have participated in that conciliation proceedings. Did you raise that objection, Mr. Basu, at any point of time?
Yes, not
How it has been dealt with?
But, that is the point, to be decided.
How it has been dealt with?
Dealt with, according to me, is not in proper perspective.
No, your point is a short point. You say that,
This is only
yes. So you have raised that point.
Yes.
Show me that you have raised how it was dealt with.
120.
120.
There's an order include.
This was taken up earlier.
After
Well, on one occasion,
After 4:30 matter was called down, my landed friend, I don't know why he has jumped up. Mr. Rosmata Maraji or the opposite party.
But there are many flag marks here. That is why I'm asking you.
Oh, that is
Enter.
because that's his Basu problem.
It was extensively hard.
This is Basu.
So I'm releasing it. Extensively hard. From the flag marks, it appears.
Pragma, not hard.
Yes, yes.
Kindly come to 120.
120.
The supplier unit was registered MSME by number 31st May 2011. Yes, admitted. Which reveals that the supplier unit was a registered MSME before the date of agreement and also the date of invoice for returning to the buyer unit. Notice it. Now the third. Next, it was found that all the invoices were raised after the date of 23rd December 2015. So, as per the 15 of the MSME Act, case is maintainable in the council. In the Uddiyana Register certificate, it's found that the service item, real estate activities with owned or leased property is incorporated one of the items of service. When? That is the point. That is the point. According to me, it is long after.
No. So show me that you have raised that point.
This is
So
that's why I have raised. That's why this decision was given. This is the finding.
oh, this is the finding.
I raised. That's why this is the finding. Is it said that is maintainable?
No, show me that you have raised that it was incorporated subsequently. Where is that?
That is admitted fact. That is admitted. Well, I am showing to Lordship when it was incorporated. Now, kindly come to.
No. So the council finds that the relevant nature of the service is present in the registration certificate. According to you, it was incorporated subsequent.
Not admitted, it is admitted fact.
Yes.
Proceed on the basis of admitted. Kindly come to page 26.
So the conciliation failed. Conciliation failed.
Yes.
Then referred to arbitration.
Under MSME, not,
Yes, yes.
not Arbitration Act.
Under MSCB, but the provisions of the Arbitration and Conciliation Act will be followed.
But it is not an arbitration.
It will be under award under that because there is a under that act some body has been said to be the arbitral tribunal.
Whether he can invoke MSME. Date of the document is 22nd day of 2018. 22nd May 2018.
Show me that certificate.
Yes.
So page 120 is the finding.
Page 128. Can you come to 128? This is the point.
128.
This is the subsequent one. Can you come to 125?
Yes.
125. Can you see? When you come to the bottom of the box, can you see? Come to the second NIC 4 digit.
Yes. Yes.
NPR of computers and peripheral equipment.
So this is the nature of the work.
This is the original.
Original.
Under this.
All right.
And can you see the date?
So page 125 is the original.
Can you see the date?
Page 125.
Date of filing 23rd December 2015.
It is the original registration certificate.
Yes. Which incorporates repair of computers and.
What is the date?
2015.
Where do I get the date?
Next bottom of the box. Date of
Oh,
filing.
23rd December 2015.
File.
No, 23rd December 2015. And where is the subsequent registration? Where is the subsequent registration?
For that, after this, my agreement with Mr. Banerjee's client. When this subsequent incorporation was not there.
Yes.
To 126. 128. Can come to 128.
Yes.
Just bottom 68. Real estate activities. Right side, my lord, extreme right, my lord will find this is not properly legible. I have recorded it. 12th or 2nd January 2022.
So now you entered into real estate activities also. Initially computer to real estate.
Diversification. And now, my lord, can you see my agreement?
So this is now real estate activities.
Now, my lord, can you see the date of my agreement with Mr. Banerjee's client?
So what is the date of this?
Which one?
This incorporation.
First.
Where do I get the
January
date?
2022. Extreme right, bottom, last.
12th January 2022.
Fine.
Yes.
Now, my lord, kindly come back to.
Where is the agreement?
26.
One.
Only 26.
Only 26.
It's only for the date.
You started with three-digit figure. Now you have come to 2G.
In such a manner, I told 22nd day, May.
What is the object behind this, Mr. Basu? Starting with 3-digit, now coming to 2-digit.
Shorten the point which I want to raise.
26.
Yes.
Yes.
If I say this first, I will not be able to.
This is the agreement.
A date. Can you see the date? Nothing else.
So agreement in question is this is the
Agreement. When it was entered?
22nd May 2018.
15 registered originally. 18 agreement with me. 22 real estate entered.
Yes.
Yes, to my lord now.
Maintainability क्यों?
Maintaining. Some maintenance.
More. First, Malad has to overcome the question of maintainability and Malad deposit because it's challenging an award. Deposit 75% Malad has to be given before Malad all this can be taken up under section 19
I am not in appeal.
of Malad the Act. Doesn't matter. You can't bypass that.
I am not in appeal.
Section 34, it's an award. You have to take all these points under section 34. Even assuming.
No, 34 is the award is challenged.
Yes.
But he is not challenging the award.
He is challenging the award.
He is saying that conciliation failed, thereafter referred to arbitration.
And the award has been passed. His challenge is to the award.
That is without jurisdiction. If I
Whatever it is, that also ground under section 34. That's also ground under section 34.
A challenge against
and as soon as you get into the award,
for one of the grounds is nullity or without jurisdiction.
And section 19 says you have to deposit 75%. He's occupying a commercial property for the last 5 years. No rent, nothing. No rent, nothing. No, divorce decree doesn't say for stay you need.
Where is the act?
Yes, can you have a look?
আরে
copy act কে দাও
আনাননি এটা এমএসসি তে আনিয়ে নিন তো সারাক্ষণ এমএসসি এর মামলা হচ্ছে আনিয়ে নেবেন
and I'm sure my learned friend will first show the maintainability point.
Yes, arbitration একটা দিন তো আরবিট্রেশনটা কোথায়
ঠিক আছে আমার arbitration act has.
Yes, I have got.
(34) 2B.
(34)
2BI.
34 2 BI. This court finds that he is not capable of settlement. Yes.
Yes.
So this is the ground.
Yes.
34.
Yes.
And show me that that deposit
And that's section 19 of the micro, small and can you look at section 19 of that? Proviso.
Application for setting aside any decree or award. Unless the appellant has complied with 75% of the amount.
Shall not be entertained by court. And I'll show a judgment, my lord, it can be filed, cannot be entertained.
So let me
In effect, 34 remedy is there. You file a 227 and you say you set it aside.
You file an application under section 34.
Let it not. If it is without jurisdiction.
Yes, sir, that is a ground. That is also a ground of the 34(2)(b).
Let us see this.
Second is, even if you cannot bypass that and the constitutional court can ask you to deposit that.
Just a minute. Just a minute.
Even if you say entertaining, yes, but the constitutional court can impose conditions.
That is discretionary. I am not on that.
So discretion, so yes.
That depends upon, my lord knows. My lord knows
I'm bound by a division bench judge.
My lord knows when the decree is passed for eviction in appeal, it is the discretion of the court to impose cost order for conditional. It depends upon case to case. No straitjacket formula. In some cases where the court finds this decree cannot have.
It's a money decree. Show me the decree or the award. It's a money award. So money award, stay if you want. Stay if you want.
There is no straitjacket formula. Let us come to the.
Stay if you want, Mr. Basu. The court can ask you to.
My lord has to see who has passed this order. Today, my lord.
Mr. Basu, that is also a ground available under section 30.
Let us see what is the language there. Can
yes,
let
yes,
us see.
yes,
34.
Yes.
34, my lord.
Yes.
34, which ground, my lord?
2B.
2B.
B, small b.
Small b nahi.
Yes, Mr. Banerjee.
Yes.
What book you have given to Mr. Basu?
PIJ.
Oh, I didn't want to comment. He is on purpose ignoring small b.
Subject matter of the dispute is not capable of settlement by the arbitrator
He's big
under the law for the timing in force.
That is your submission.
No.
Yes, subject matter. Mr. Basu, you say.
It passed the conciliation stage.
No, arbitration.
Right.
Yes.
Right.
So, Mr. Banerjee says arbitration award has been passed.
Yes.
So, if the arbitration award has been passed, now you are challenging the arbitration award. So, if you are challenging the arbitration award, it has to be under section 34. On ground 2B.
No. I should not say no to court. I remind me Justice Greenberg. Kindly read. Once again with me.
Yes.
The court finds that subject matter of the dispute is not capable of settlement by arbitration.
Yes.
Under the law for the timing in force. This is not.
That is exactly your submission.
This is not inherent lack of jurisdiction.
No. It does not say inherent because Mr. Basu, you say that since this nature of activities was incorporated in the or inserted, whatever it might be, in the registration.
Jurisdiction.
In the registration. Yes. So that is subject matter of the dispute is not capable. Jurisdiction is also a part of that. Jurisdiction is also a part of that, Mr. Basu. There are two things. You can approach 34, yes, or if you want to proceed with this matter, you deposit that. I will ask. I will allow you to make submissions here.
Is it the intent of the legislature that a court who is inherently lack of jurisdiction, inherently.
Even 34(2)(4) also, my lord, has specifically.
These when these alternative remedies are there under various statutes requiring a pre-deposit. Various statutes, as in the surface, you will be finding in other statutes also. So there is a requirement of pre-deposit as a condition of stay. So if yes, no, in some cases you will find that there is a question of waiver to some extent, not the entirety. There are some says no, you have to deposit that unless there is a provision for waiver. So you have to comply with that. There are some authorities which says that if it is the demand of is so exorbitant.
Onerous.
Yes, onerous, then it's the discretion of the court. Court can allow without that. That's the other thing. Discretion is there. There are few authorities, but considering that in order to curb this, because this will be, we will be trying to bypass the statutory remedy by way of approaching the constitutional courts.
Beyond the statute. I am beyond the statute. If that cannot be equated, one, a court has, there may be possibility of lack of jurisdiction, passed an order, this question may arise. A court has passed an
You
order.
deposit, you need not pay to Mr. Banerjee's client. You deposit in court. That can be done because
I want to answer this one of these question. It was not because I was not there. It was not
because money degree, if you want stay or money award, court can impose, secure that.
doubt about that. But I given an instance. A court having no jurisdiction
Yes, you will get refund of that amount. You deposit in court.
to me.
You deposit in court.
The court having no jurisdiction put me in this another situation. Same yardstick.
Mr. Basu, the fact remains, there is initially must be a conciliation proceedings. So there you did not take any point or you did not challenge at the very initial stage. Look, you do not have jurisdiction either to initiate, also to initiate the conciliation proceedings. So you participated. Now it's the now after the Mr. Basu, if that is so, you have not challenged, you have not approached at that point of time. Then after conciliation, you have participated in the arbitration. Now the award has come. Now you are challenging.
With this point, I participated. What can I do? I will not participate. I raised that point.
You could have challenged that, Mr. Basu. You could have challenged that earlier.
Then
Court message that you could have no. That is a different thing altogether. If that was the point of jurisdiction, you could have approached prior to the passing of the award.
I anticipate. I have raised this point with the clear mind that court will adhere to me this point and come to my rescue. That court has no jurisdiction.
No, there are two stages. If I am not wrong, there are two stages of this. Initially, a conciliation.
Yes.
Thereafter, if the conciliation fails, then it is referred to arbitration. So, according to you, if this procedure, this act is not applicable to you,
I raised this point.
so you ought to have raised initially at the conciliation stage.
Conciliation stage, my lord, it is, my lord, private negotiation.
Maybe, Mr.
Can negotiate.
No, not under this act. Not under this act. Conciliation is a different thing. Conciliation under this act is who are registered under MSME, not all. So when you accepted the jurisdiction, did not raise at that point of time.
I raised this point. When the arbitration commenced, I raised this point. And this is the answer, my lord. Son. What is the answer?
In the conciliation stage, you did not raise.
No. I must be candid. No, they have noticed.
Waived it also then.
No, it cannot be. Because
I'm relying on section 34.
Where is the provisions for conciliation, Mr. Banerjee?
Yes, Malad. Malad, section 18. Section 18, subsection 1, subsection 2, subsection 3, then subsection 4.
Yes. So
conciliation
contained in any other law, any party to a dispute with regard to any amount due under section 17. So it's only for this. What is 17? For any goods supplied or services rendered by the supplier to the buyer shall be liable. So unless it is so, this 18 comes in respect of a dispute which is falling within the scope of 2006 Act.
May I answer? Conciliation, result of conciliation is not binding on you.
Maybe, but you.
In conciliation, the authority cannot pass an order you pay.
Mr. Basu, no, you should have said, no, you do not have any right to conciliate even.
If had it decided, no problem. Had it been decided, it is we both the parties.
You subjected to the jurisdiction.
No.
You subjected to the jurisdiction.
Correct.
comes when the arbitration starts.
No,
And the arbitration award is effective.
No. This is arbitration is after that.
Reference.
Arbitration is reference upon failure of
Yes,
conciliation
that's
as
3
per
and then
this
4.
act.
Absolutely.
This is not an arbitration.
It is absolutely correct. Arbitration.
Maybe 3. 1, 2, 3.
Mr. It's the second stage.
Claim file arbitration.
Yes.
There is no claim before the.
Mr. Basu, there is no dispute with regard to that. But there are two stages. First is the conciliation. If the conciliation fails, then it is referred to the arbitration.
Right.
There he will be filing claim application, defense statement.
File. There may be no claim. There may be no arbitration. After the conciliation fails, there may not be any arbitration.
No, this is no. It has to be referred.
Yes, it has to be referred. Section 18.
Referred.
It's not a private
Failure has
conciliation.
to be referred.
Yes, 18.1, then 18.1, 18.2 and 18.3.
To be referred.
Yes.
What is to be referred?
This, Mr. What to be conciliated? What dispute?
Yes.
Claim and
Mr. Basu, dispute. Dispute has to be conciliated. That dispute, if there is a failure of conciliation, that will be referred. If you say there is no dispute,
if that be so, then there is no question of filing any claim.
that is Mr. Basu.
There is no claim.
It's difficult to digest because unless there is a dispute, the question of conciliation does not arise.
A dispute.
Yes.
I got so much.
Not been referred. Referred is claim. Claim is adjudicated.
Mr. Show me that reference to the arbitration. Show me what has been.
Claim is the dispute. It
Show me
should
the
be a
reference.
Claim before the arbitration.
Mr. Basu, show me the reference order by the council. Show me the reference order by the council.
Reference order.
Yes, it has to be referred to for arbitration. The council has to, conciliation council has to say, conciliation failed, matter referred to arbitration. Show me that order.
That is not with us.
Has to be.
They could not with us. Only my lord, when the claim was filed on.
Option that, yes, Mr. Banerjee, do you have that? Because it
Just
has
not
to.
find out. Is there pleading? I'll find out.
It has to be Mr. Basu, otherwise it cannot be directly referred to arbitration.
Claim filed. Claim has been filed.
Claim, thereafter claim will be filed.
Page 97, you will find advance notices are served for 4 conciliation hearings to emails to both parties to appear before the council for conciliation on 22nd March and 29th July.
I am already asking for the order.
আমি এখানে যা আছে সেটা পড়ে দিচ্ছি।
Asking for the order. How is it referred?
My learned friends, client Mulad will be well advised. They're occupying Mulad from 2018 and 2019. Mulad not paying rent. Mulad running a bar cum restaurant. Mulad they should really Mulad think about paying. 5 lakh টাকা per মাস না দিয়ে আচ্ছা ক্লেম হলো 2 কোটি 31 লাখ টাকা।
Mr. Banerjee, don't quote the figures. Accepting figures.
They can, but we cannot. So only my lord, page 63
Original 2 কোটি।
was served upon me. I came to learn there is a.
No, that's not what it says.
My lord is perfectly right. My lord, I would not say what is the reference. After dispute is not settled, it must be referred.
Yes. Please kindly come to page 97. The procedures, bullet points. The procedures followed in the conciliation process. So these are the procedures. Then last bullet point. Yes, conciliator then decided to terminate the process of conciliation and initiate the process of arbitration as per 18.3 and 18.4 and was duly communicated to both the parties by memo dated such and such. Where is that memo? So this is the failure termination of conciliation, then reference to arbitration. That has to be done.
And Mullah, just read Mullah the 2 bullets before that. Mullah, just kindly read Mullah the 2 bullets before that.
Yes.
Advance notices were served for 4 conciliation hearings through emails to both parties to appear before the council for conciliation on 22nd March and 29th July. Any settlement between the parties, just the bullet before that, could not be arrived at in conciliation.
I've seen that.
Hearing that.
I've seen that it failed.
Yes.
Thereafter terminated, thereafter reference. So these are the
conciliation
stages.
is only under Mullah the act itself.
For conciliation, there will be a claim. There is a dispute. But then, page 63 for the first time referred as a claim before the authority.
conciliation is
How?
a dispute.
How?
That is a
Dispute,
dispute.
dispute, my lord knows, plain written statement, dispute. What is that?
Who approached before the conciliation council?
Not we.
We refer.
What
We
is
have a
it?
claim.
Show me your application before the.
We don't have it here. It's their petition.
Where?
Well, it is there. We don't have it here. Well, we'll get it. It's their revisional application.
They have
They
not
not
annexed.
No.
That has to be there. That's the dispute.
Then why this is 63 claim then again?
What?
That is the claim before that we did it.
Mr. Basu, that has to be, that's the procedure. Once it is referred to, you have to file. Arbitrator cannot decide on that. Disputes, conciliation failed, thereafter arbitration. Once the arbitration starts, then the statement of claim has to be filed.
Then
Has to be
what was
filed.
conciliated? Then
It
what was
says, Mr. Basu, it says one application was filed in, this is how it is done. Samadhan portal, video application number Sansaj, 7 February by the petitioner, supply unit, realization of dues from the respondent. That's the first paragraph in page 97.
Then what is the
No,
claim?
That is the buyer unit,
I've seen.
Mrs. Commoners.
97 I have seen.
Yes, petitioner also submitted a physical copy of the case documents to the buyer side rightly.
Only point is which relevant, but according to my humble reading or hearing the submissions or observation of my lord, that whether an order which is since its inception is bad in law. Since its inception is bad in law, but I have to go to the rigors of filing an appeal. I am before the court or under 27. The exceptions, my lord, your lordship knows whether I am coming under the exceptions of those, or I can challenge. I am bypassing. I am not saying I can. I am bypassing the rigors of 34 and approach your lordship's court only on the ground that the order on its inception is bad in law.
Mr. Banerjee, under the Arbitration and Conciliation Act also, for setting aside for stay, so there is a provision.
Yes,
for
36. Well,
That
first,
is also
kindly look at section
That is
34.
also there.
That is there, I know.
Yes.
Well, kindly look at first, section 34.
Yes.
May I just show B. Before that, kindly see 34. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Then note is 2. An arbitral award may be set aside by the court only if, then note is A4. The award deals with the dispute not contemplated by or not falling within the terms of submission to arbitration, or it contains decision on matters beyond the scope of the submission to arbitration. This is our ground. Then yes, so that's a ground.
34. Mr. Basu, when this specific grounds, because 34 is very, very limited. The scope of 34 is also very, very limited. And these are one of those files. It's not an appeal. Recent decisions, it's not an appeal, it's very limited. If you fall within this.
34 is arbitration proceeding, either appointed by the
Basically jurisdiction.
Under 11.
Basically jurisdiction point.
Either appointed by the court or agreement by the parties. There is none.
The act says.
Right. Now we are coming to act.
Yes.
Now act comes to force.
Yes.
Act says if you are only MSME and having that part, which I argued, then the MSME authority having jurisdiction. These are the distinctions I want to canvass. 34 in a case where agreement with the party somebody appointed, and 34 or court appoints. So presumption is that the arbitrator has jurisdiction. Presumption is arbitrator has jurisdiction because the court has appointed and agreement between the parties appointed. Here the arbitration is the product of a statute, and if the statute says that an MSME and the MSME only having this qualification.
When this arbitration started and when the award was passed, did you raise any objection challenging the jurisdiction of the arbitrator or the council?
That is, I told you, lordship.
That is the,
That's
that was,
fitting.
when did you raise that point?
By filing objection. By filing objection.
And that was decided finally.
7
February
2022 is when the conciliation started.
But Mr. Banerjee, if Mr. Basu submission is to be taken, he says that before the arbitration council, I think that's the council there, before the arbitration council, he raised the point of jurisdiction of the council. But
In
that was,
arbitration also be raised that.
yes, section 16, you can raise that.
Correct.
But when a point of jurisdiction is raised,
Yes.
that has to be decided first.
It's been decided.
So he says, Mr. Basu says, that has been decided in the final award, not prior to that.
They never preferred, my lord, if they wanted, my lord, that to be decided first, they should have pressed for it. It is
That is
decided
Mr.
here.
Basu says. Mr. Basu says that yes.
He may say that, but in my lord here, my lord, I'll tell my lord, this unit was already, my lord, registered as an MSME. It, my lord, registered, their additional registration was done in 2020. It's an issue, my lord, whether they went by the registration of earlier registration 2011. The issue is, my lord, whether that is correct or not correct. Whatever it is, my lord, now today there's an award. Either you want to challenge it under Arbitration Act, because award is an award, it's under Arbitration Act also. So either you challenge it under Section 34, which one provides also that if there's no jurisdiction, you can have an award set aside. But
in the MSME Act, to challenge the procedures of
Section 34.
That will be,
yes,
that has been made in MSME Act, that has been provided.
In
in arbitration, that will be guided by arbitration.
It is, my lord, it's an interplay, my lord, both between Arbitration Act and, my lord, the MSME Act.
Where is that?
Section 19.
19.
Kindly, my lord, first look at my lord, first kindly see 90 days.
It seems that today I
18, section 18, subsection 4.
Yes.
yes, today
Notwithstanding anything, I'm sorry, এটা পড়ে দিই একবার। এটা আমারটা তো বোধহয় কি আছে। আমারটা কত? নতুন এক থাকলে দে ভাই আমি পুরো না
independent.
because of the judgment which has been amended now. Well, it has 18.4, my lord, it should read
18.4.
where the mediation initial and subsection 3 is not.
No, 18.4 is notwithstanding.
No, sorry.
No, which act you are placing? MSME?
Yes, my lord.
Yes, MSME is notwithstanding.
19 this
কি দাগ
week,
আছে?
my lord.
19, I think.
19.
So 19, so it's not 34. It does not say the arbitration provisions of the Arbitration Act will be followed. So 19 gives a provision for setting aside.
Yes.
Independent of the
Yes.
independent of the Arbitration and Conciliation Act. But the provision is
yes
similar.
So, my lord, at the end, my lord, even under
Language of both.
my lord, kindly.
19 and not
But Mr. Banerjee, the thing comes, one point, 34, those sub-clauses are not there in 19.
No, setting
what
aside has
count?
to be under 19, 34.
Where is that?
Setting aside. Oh, that my lord will either, my lord.
Where
My lord, may I, my lord, also, my lord, my learned friend has to show that, my lord, under Article 226 and 227, first of all, he can set aside the award. Because I'll show also, my lord, now, my lord, it's been referred, my lord, so far as 226 is concerned, been referred to a larger bench. Whether, my lord, can be set aside or not.
No, yes, it has to be, no, that is, he says, you are right, it has to be before the court.
Yes.
And
shall be entertained by any court.
Court has been defined here in the Act.
By any means, it cannot be excluded by 227 court.
No, but Lord, why should, my lord, today, my lord, that be allowed to bypass?
Mr. Basu, there is a decision on this. I forget. One statute is, I think, in PMLA, where it can be done, court and other things. There are something also court. Whether that the question propped up whether the constitutional courts will be excluded or not.
Cannot be excluded. That's the answer.
So that's no court has been defined here. No.
Court is, my lord, I don't find, my lord. Court is, my lord, not defined in section 2.
But here, Mr. Banerjee, subject to correction by you, it does not say the after award all the provisions. You will find in some act it says after this provisions of that act will follow, like in a Land Acquisition Act, and so those are there. Here it gives an independent provision for setting aside. It does not say yes. So the grounds on which this setting aside may or may not be as in 34.
Now it is rescission of the court. Not binding. 34 is a binding effect.
Under, if it is not under 34, but it's under 19, whether the rigors of 34 will apply here.
Well, for setting aside, it has to apply. And not only that, I think we are not
Banerjee, because there are two things. It gives an independent provision for setting aside.
Here, no.
Yes, yes.
No.
19.
19.
19.
Kindly look at 19.
Yes.
Kindly look at 19.
Yes.
No application for setting aside.
Yes.
Any decree, award, or other order made either by the council itself or by institution or center providing alternate dispute resolution services in which a reference is made by the council shall be entertained by any court unless the appellant has deposited with it 75% of the amount in terms of decree, award, as the case may, other than the other order in the manner directed by such court.
Yes.
And pending such disposal application or order that such percentage.
So that is
it only gives a condition as to when.
How do you say that 34 has to be applied here?
I think under the new amendment, I don't know whether I also.
Amendment of what? MSME?
Yes.
MSME?
Yes, yes. I don't know what is the 20.
Because here, if we will be finding in many statutes, it may say up to this, after that, what is the National Highways Act, what is there? National Highways Act 3G is also.
Section 4, all proceedings of the organization will apply.
Yes. You have a National Highways, now the gadgets are here. Can if any one of you find it out? National Highways Act.
Arbitration Conciliation Act perhaps will not apply in that case. It's a statutory arbitration. But in this case, it gets with the
If 34 rigors will not apply.
in this
No, here, in this case, it will. That's the only award.
Yes.
There's no other setting aside provision, in the Act.
There is specific.
Yes,
19 is only deposit if you make an application for setting aside. It's not setting aside, doesn't lay down the conditions. No, it doesn't. It doesn't give conditions.
Banerjee, do you have an authority on this? Whether the rigors of 34 shall be applied in a setting aside proceeding under the MSA? You have authorities. Please show me.
I was hoping Mr. Basu first has to show it is maintainable.
I am saying it is maintainable.
He has to show judgments on that. Let him show
Yes, yes.
Let him show that 226, 227 maintainable. What is the law on that?
Because there are two things. One is, if it is not 34, then the scope will be wide. Maybe wide. I'm not saying will be wide. 34 mentions that you may say yes, if it falls under that 34. Now, if it is wide, then the question whether.
Put it this way. Question of jurisdiction is also a ground under 34.
Yes, yes.
It's an award.
Yes.
Section 19 of the Act says that no court shall entertain unless you put in 75%. That is obviously to protect the award.
That is the stay part. Or
that's the stay part. That's not the setting aside.
Pre-deposit part.
Because it doesn't either define court, nor does it define on one ground it will be set aside. It's an additional attachment to an award which has been passed by the MSME Council. So either let us take it. Either you go under the MSME Act or under the Arbitration Act, or you come under other procedure. Mr. Basu has chosen he wants to come under Article 227.
With the exception clause. Which
227. He is also taking a question of jurisdiction. I am putting in Section 19 also to show that if the Constitutional Court also has to entertain, it should not be without conditions.
That I will.
It will not be without conditions.
That I will consider.
Today, otherwise, he bypasses the whole procedure of the MSME Act also.
National Highways Act.
Today, in the given situation,
I think there also the arbitration proceedings is there.
They not being appointed by the
mediation. That's why. Substitute 23.
And that has been challenged. Same rigors. You have to deposit.
Let me check up. I think 3GH. Yes, 3G5 is the arbitration. I think thereafter it has been said that the provisions of the Arbitration and Conciliation Act, that is silent here.
No, here also it now says with amendments. We have just asked for.
Metro Rail also same. Metro Rail. After 3 capital A, thereafter land acquisition proceedings.
My lord's book, is it which year, may I just find out? Sorry.
2014. I think there has been amendment after that.
Several amendments.
Because those mediations are
I have 2021, 2023 there's an amendment, and there is a subsequent amendment also. I think we need to consider the act.
I think some mediation or other thing has also been incorporated.
Correct.
Mediation Act has also been incorporated in MSME.
Because it's from Arbitration Act, the conciliation has gone away, and now it's with the Mediation Act.
I fail to understand. Before coming to court, there are at least 5 failed mediation. Pada level, Bondhu level, now political level. After coming to court, again mediation. I personally fail to appreciate.
যারা টাকা চায় না তারা যত মিডিয়েশন তত ভালো
একই হবে
আমিও কোনদিন তোমার দিকে থাকতে পারি
রেগুলার থাকি
আজকে you don't have to give money so obviously I think we need to get a copy of
and if you have got some authorities on this, because for setting aside which is to be followed,
sorry
for setting aside whether 34
it says 1996 Arbitration Act will apply.
Where?
It's the new provision.
Does it state there?
2020, yes. 2025, this is what it says.
No,
19 is also there.
So 19 is with regard to the.
I was. I think 2025.
Which section, Mr. Basu?
Section 18. 18, Malad, can you look at 18?
Yes, 18.
18. 3, 4, Malad, 4. No, I'm up to 2021.
Arbitration.
18, subsection 4.
And the provisions shall then apply. Then it's 34.
19 is also there.
19 when 18(4) says after termination Arbitration Conciliation Act will follow for reference. So if that is so, all proceedings will follow. And 19 is an additional for that, maybe a surplusage you may say.
Obviously.
Maybe a surplusage, but the provisions 34 will apply. Please check up this 18.
No, even this whole act also, Malad, even before that also this says so. I have a 2021 book. So that also
2014
says.
2014 it was not there.
No, 20. Malad, this is there from
14. I think Mr. Basu, please check up 18(4).
This 2024, I may.
2024 you have got. No, this is 2025. This is, I think, the latest one.
Yes, yes. Malad, 18(3) says so. Tomorrow copy 2024 I boy. That's 18(3).
I was given 2014.
No, 2021 also has this one. 2021 also.
Mr. Basu created this problem, giving a
yes. I was also very confused.
2014 book.
Because I never want to challenge Mr. Basu's submissions on law.
Conduct of mediation under this
And
section.
particularly assisted by my.
Yes, yes, 1997.
Which one, my lord?
18(2), 18(3), all says Arbitration Conciliation Act.
Just a minute. On receipt of reference under subsection 1, the council shall either conduct mediation itself or refer
আমাদের
the
বইটা
matter
কবে কারা নিয়েছেন? MSME টা
mediation service
কোনটা?
provided
না, না। দিন লেটার
book also has.
Yes, yes. Now 2020. No, problem created by Mr. Basu giving the 2014 book.
Then what is the effect of 19?
You have to deposit. It's an additional condition for MSME.
19. No. Let me see. 34.
19 also same.
No, 34. What is the pre-deposit? 36.
No.
What is the pre-deposit?
Or as the court thinks fit. Like a money decree.
So, yes. So if that is as the court thinks fit, and here it's a limit said, so that will prevail. That will prevail over that general.
High Court says 100%.
Money award
100% compared to order 43 appeal.
Yes, please check up whose book is which
yes,
one.
I think both.
If today, without being appointed by the court or not by the parties, I passed an award. Suppose passed an award. That has been challenged by Mr. Banerjee's client. What is the effect? Same rules apply. My lord is not saying yes, they cannot be.
Mr. Basu, please consider those line of decisions.
So judgment where it says if the order is without jurisdiction.
One is whether there are two aspects.
Within jurisdiction, I
There are
can
two aspects. One is, yes, what you are saying that if it is without jurisdiction, yes, there are decisions which says you can, but even if there is an alternative efficacious remedy, you can. But Section 34 stands on a different footing altogether.
allow me to repeat.
Lord, I have a question.
Other statutory remedies and 34, these two stand on a different footing.
Subconscious was passed an award.
No.
Without being appointed by the court or by the parties.
Mr. Basu,
that has been challenged.
I've heard that, but with regard to this pre-deposits, there are some line of decisions which.
Lord, why should the court today?
Even then, a person who has passed an award is having no jurisdiction. Even then, it is deposit.
Lord, why should the court permit him this
No, I passed
luxury of having this litigation without a free deposit?
Heard the learned senior advocate, senior extensively लिखे दिन. Heard the Till when this matter is running in the list? So, till now, nothing has happened. When I have taken up, you are saying.
But insolvency on the
Pass this,
insolvency,
pass that.
my lord, insolvency, my lord, is not on the ground of, my lord, the award. Insolvency is on the ground that you have not paid. Now, my lord, rent is, my lord, considered to be a debt.
That has been.
No, you can't stop. You don't want to pay here, you don't want to pay there. Then maybe you are insolvent.
This is the date.
You're
Call the
insolvent.
next matter, call the next matter.
I'm grateful.
My lord, before my lord, the just earlier matter was mine, my lord. My lord, Mr. Basu, the matter, previous matter was going on, my lord. I was inside the courtroom, my lord. My lord.
Mr. Basu is responsible. Sue him.
My lord, I just please, my lord, the previous matter. My lord,
Take that ground in the restoration application.
my lord, kindly, my lord.
Take that ground and cost will be realized from Mr. Basu.
Kindly, my lord, previous matter, my lord, kindly take it.
What is the item?
My lord, 741, my lord, 741, my lord.
741 কি হয়েছে ওটা 741 কি হয়েছে
It was, I have learned, my lord, it was dismissed, my lord.
This is for default.
Kindly take it up, my lord. Kindly take it up, my lord.
741 টা আছে ফাইল না চলে গেছে দেখুন
My lord.
3:30 PM.
30
3 PM matter. My lord, concluded.
Take it up, then my lord, kindly take it up tomorrow, my lord. I beseech your lordship, my lord.
3 PM which item
35.
35
My lord, amendment. My submission is not necessary.
Who is your other side?
Mahato.
Where is he?
Because my submission, he has argued. My submission, the amendment is not necessary. And there is no prayer for cancellation of the deed.
All right, I will please wait for 5 minutes. Can you inform Mr. Mahato? Please inform, ask him to come. Mr. Bakshi will be available tomorrow, no? When he will be coming? If Mr. Mahato is not, please see whether Mr. Mahato is available or not. আছে এই ব্যানার্জি
Just আগের মামলা আরো আছে 6 matter ওখানে
So Bakshi, take your seat, please take your seat. এই 4টের সময় ফরওয়ার্ড আসতে রেখেছিলাম না other side
no my lord, no other side, my lord.
tomorrow.
I bow down to your lordship, my lord.
Yes, call the next
Yes,
matter.
my lord.
Item number 933. My lord, I appear on behalf of the petitioner. Huh?
Monthly is 933.
933. 33.
What is your item number?
38. 938.
933 কে আছে দিন
933 কে আছে
নেই So this matter, you had 933?
38.
None appears for the petition. This matter was.
We are for the opposite party number 1.
Yes.
My lord, in a suit filed before the learned Waqf tribunal by a local villager, my lord, describing himself to be a welfare of Waqf estate. My lord, claiming a declaration for a secular property to be declared as Waqf by user. My lord, the owners of the property are not impleaded.
CS, RS and LR records stand in the name of the owners, thereby prima facie demonstrating that the property is a secular property. The point of limitation is raised. Who is impleaded? The attorney of the owners is impleaded as a party, saying that he is causing disturbance. He files a written objection in the injunction application, raises a point of maintainability, that even the 1954 Act prescribed for a 30-year limitation, and the 1995 Act, which does not prescribe for a limitation, also does not say that an extinguished claim will be revived. This issue, I had the privilege of arguing before my lord, when my lord was taking up writ petitions, and old writ petition came up. That judgment, I am unable to find, but the judgment relied upon therein of the Honorable Supreme Court. That makes the issue very clear. And now my lord knows that 107 under the new Act of 2025, that has been omitted, saying that the Limitation Act would apply. Although I am not on the new Act as much, but I say if the CS, RS and LR records stand in my name, and the owner is not impleaded as a party, and the plaintiff cannot satisfy the court on the issue of locus standi, there could not have been an injunction against the rightful owner. I have come up against that order of injunction before my lord. What is the injunction? Nature, character, no construction. So it is virtually stopping me from doing anything. I say these issues, I have raised.
Possession.
I am in possession. I am in possession. I can't make construction.
Who is the plaintiff?
The plaintiff is a villager saying that he is a well-wisher of Waqf by user.
Where is the plaintiff?
Yes. Kindly,
how much time we will take, Mr. Choudhury?
I only kindly I would show two lines and say that
he has to be hard because
no only I am making an innocuous prayer.
Not more than 5 minutes.
I am making an innocuous prayer in as much as the issues which I have raised, one of limitation, other of the locus standi, has not been decided by the tribunal at all. I say that let the issue be decided once again by taking into consideration my written objection. Kindly cease. I would
because he has to be also hard.
Yes, yes.
But I not take more than 5 minutes.
But is my learned, let us understand, is my learned friend objecting if the application is reheard?
No, Milord, I am objecting because
then
he will object because no, he has obtained an order of injunction. Rehearing means it is to be set aside, Mr.
Yes, yes.
Not that, the primary, his primary declaration in I am making it not today. So if the injunction is vacated, nothing remains. Tomorrow, Mr. Chaturvedi, I do not know what will happen tomorrow.
Yes, yes.
Not either because the time will be short.
Yes.
So might be difficult because my endeavor will be to proceed with the motions as far because fixed matters because today I think only one.
Then could it be on Tuesday?
Remain. If possible, it will be taken up. Monday also, I do not know what.
No, Monday.
Can you not fix any matter?
But could it be?
If you want, I can keep it on Monday. No. Tuesday or Wednesday,
Let
it remain. So thereafter.
Could it be on Tuesday, subject
to fixing because here it is fixing it will be a problem. I'm making it not today in case you have difficulty. Tell me.
No, but otherwise, this will my lord would take from the next item on the next.
No. This I will not take.
As my lord says. I'm grateful.
Previous matters have been finished except the Banerjees that dismiss matters.
Lord, at 3. As it is.
That I will consider because
yes,
this is
whenever.
This is I am flexible on that. I have to arrange my list accordingly.
I am grateful to my lord. Deeply okay.
Yes, Mr. Bakshi, could you find Mr. Mahato?
My lord, let it remain. My presence will not be necessary because my lord, my submission is amendment is not necessary.
Mr. Mahato has left. He is not here.
What are you?
I has not come.
35
he has prayed for converting it to Order 8 Rule 9.
I think your junior has come.
Milord, I have filed by affidavit of service. Sorry, Milord, I take it back.
Please on record.
My lord,
Where is he?
He is not receiving the call. On record, I have called my lord, Mr. Shamim Akhtar. I have called him.
Mr. Bakshi, when he will be available?
my lord, next day,
When?
one day or 2 days I come, my lord. This is a case, my lord, I don't think your lordship requires my assistance. Either to allow it or to reject it.
No, that is there.
And therefore, my lord, keep it for Mahato. Only, my lord, order 6 rule 11.
Yes.
Order 6 rule 13.
Order 6 rule 13. Your lordship.
Order 6 rule 13.
Rule 13.
Mr. Mahato, এই মামলাটি
They have not challenged the deed. I am to prove that by this deed,
Yes, order 6 rule 13. What do you want to
prove? I am claiming they are saying they are my vendor. Their title is admitted. Whether by the deed of transfer I receive or it is bad for coercion. I say this is my obligation to show that I have title by Dindo. It is not.
Oh, this is that case where the statements. Yes, you are here. Where is Mr. Mahato?
Coming, your lordship.
He's coming.
Yes.
All right. So whether the amendment has to be controverted by way of
Yes.
order 8 rule 9 is to be
You mean order 8 rule 9 does not say.
No, I think have you considered Mr. Mahato has cited this decision?
Yes.
Have you considered that decision?
Why not none of the
29.
29? So, this is not a proposition for conversion. In
Yes,
that
while
question,
granting leave a replication is
can a additional plaintiff controverting the defense is permissible? No.
when Mr. Mahato said that was my view,
No.
and he said he will be citing a division bench judgment of our High Court, but he could not cite that.
It is not necessary.
But he could not cite that. He has cited this decision on order 8 rule 9.
And my lord,
29, paragraph 29.
29, my lord, it does not apply. That
Paragraph 29 it does not apply. And what you are trying to show from order 6 rule 13.
therefore, আমি যেটা my lord,
6 rule 13 থেকে কি দেখাচ্ছেন?
আরে ওই জাজমেন্টটা my lord, it is also doubt whether by order 8 rule 9 additional plaint can be filed. That is deal with defense.
No. Please kindly come to order 8 rule 9. I think if I am not wrong, there is a judgment passed by Justice Sanjeev Banerjee on this. Justice Banerjee clarified that.
আমি যেটা দেখছিলাম এটা my lord, kindly the opening paragraph. Opening paragraph.
Yes.
2009 14 SCC 525.
It says it is defense. Therefore, where are, my lord, the defense, my lord, claim any relief, order 8 rule 9 comes into play.
No, Mr. Bakshi, I tell you that that was also my impression, because that is regularly being done. It's the defendant who files order 8 rule 9, the additional written statement. And if amendment is plaintiff is allowed, the defendant is given liberty to file order additional written statement. But it's not the other way around. When the written statement is amended, plaintiff is not given. Plaintiff is not given.
And then to my
that
lord,
is
the onus of proving my title is on me. Therefore, he cannot file objection to that. He can lead everything. order 6/30. Your Lordship will kindly see, this is my, and my lord, not necessary. Not necessary, because I am claiming title, I am to prove.
Yes.
He will cross-examine me, and that permission.
He is defending. Since he is defending,
No,
so
yes, but now he wants to debate.
Yes.
And he was giving, court said, written statement will not be allowed, but he will allow to give evidence. It's all right, because there is no prayer for cancellation of title. It would have been relevant. Therefore, it is not a relevant matter. For the purpose of ordering.
Which paragraph of this judgment you are relying upon, Mr. Bakshi?
Huh? Paragraph. It is paragraph 8.
8.
8. And
Last question. Next.
Distinction is met. Provides for subsequent pleadings by defendant. And my lord, in any view of the matter,
Provides for subsequent pleadings by a defendant. So it's
my lord,
clear.
I don't go too far, that far. I will not ask you. My submission will.
Where is Mr. Tanmay Mukherjee? He entered.
Therefore, my lord, I have exhausted. If I come, good. If I cannot come, my lord, your lordship will excuse me. Though I don't require excuse for me.
Yes, thank you, Mr. Bakshi. Yes.
Mr. Lordship, kindly take it up tomorrow. I'm not being able to call Mr. Mahato, Your Lordship.
Be-
And it's a senior.
Better to a rule and state.
Thank you, Mr. Bakshi. Item number
35.
35. Heard Mr. Bakshi, learned senior advocate for the opposite party, to start on the prayer of the learned advocate appearing for the petitioner. List this matter on
tomorrow.
Tomorrow.
Or
Remanded Lordship, may I be permitted to mention a matter, Lordship? This is, I will be dispossessed tomorrow, Lordship. A section 14 order has been passed by the DM, Lordship. I will be dispossessed tomorrow. I have filed this CO, Lordship. Will become infructuous. I am praying for stay of the order, Lordship.
Yes, when have you filed?
Lordship, I filed it on 14th, 20,
When have you filed?
12th July.
What is the date of present in the presentation form?
Lordship, it was on 16th, Lordship.
It did not appear.
No, Lordship. It appeared once. We sought for an adjournment, Lordship.
Adjournment, nothing.
Lordship will just appreciate once, Lordship. There was a
one in of course prayer that